Then when Lane came in, I asked him the question about this same area. I asked Lane this question. So let's look at it together. Does that report indicate that Phillips stated that victim Brown was the ex-wife of O.J. Simpson, the well-known athlete actor? Answer, yes, it does. And does it say, additionally, Phillips stated that Mr. Simpson and victim one had been embroiled in previous domestic violence situations, one of which resulted in the arrest of Mr. Simpson? That report say that? Yes, it does. And he goes on to talk about, Phillips told you that, didn't he? And he goes on and says, but he told you this before you went over to Rockingham. Isn't that correct? Answer, yes. And so even Phillips was then impeached. And then Phillips tried as best he could to be a team player. It seems as though they got together, and Ms. Clark tried to make a big thing out of this, but here's how he described Mr. O.J. Simpson when he told him that Ms. Nicole Brown Simpson had been found dead. What do you mean she's been killed? Oh my God, Nicole is dead. Do you recall that testimony? Yes. What do you mean she's been killed? Oh my God, Nicole is dead. Now, is that a question or is that a question? What do you mean she's been killed? They want to make something, I mean, is that preposterous? And then he goes on to say, he became upset and made that statement. Then he continued to be upset, continued to talk on the phone to himself. It took me several seconds to get him to talk to me again, to have him listen to me, and he seemed very upset. And these prosecutors would tell you, oh boy, that's something unusual about that. If anything unusual about that? What do you think? He just kept repeating over and over again that Nicole had been killed. Eventually, when I got his attention again, is when I mentioned the children. You have to remember, this conversation took place very quickly. He was talking, and I was talking, and everybody was a little excited. That's what Phillips said. And so, again, what I hope that I've done here is to let you share exactly what the testimony was. Then I asked Arnell about it. She said he was very upset. He was crying. He was saying, Arnell, I don't understand. He was very upset, emotional. Have you ever, at any time in your then 25 years, heard your father sound like that? Answer, no. She says he was upset, distraught, emotional. And then she describes him on that evening after he comes back from Chicago. He was seated with my grandmother, my Aunt Shirley, Bob Kardashian was there, the family and friends. Some of his friends were coming and going. This was in the family room. Now, with regard to his demeanor and how he appeared, describe again for the jury how he appeared before he left the room to go to some other place. How did he appear to you then? He was just very upset. He was crying off and on. We were watching the news, and he kept talking to the TV saying, you know, I can't believe this, I can't believe this. In shock, upset, and disbelief. And I've read the other part for you about the police officers going in the back door, but she describes how they walk around and she opens the alarm. She's the one that went in and let the police in, and she's the one who walked in first. And then even Tom Lang. It's a personal favorite of mine, but in his instance, I think there are probably more mistakes than anything else. Human foibles, and he seems to be quite different than some of the others. Remember, he told us how he took these tennis shoes that O.J. Simpson told him he was wearing. And I said, what'd you do with those tennis shoes? He said, well, I took the tennis shoes and I put them in the trunk of my car. I was going to take them home for the night because it was too late to book them. Then we looked at this video. And the tennis shoes he got, remember, he put the tennis shoes in the front seat with him. Maybe he stopped halfway up the road on the freeway and put them in the trunk. But that's not what he did then. And then he was part of the group who says O.J. was not a suspect. Turns his head, perhaps. Maybe that's his partner. But you notice he wasn't involved in this whole debacle with these Fiato brothers and Agent Wax. He wasn't involved. He's smarter. He wouldn't let that happen. And you know what? It's interesting because it's his case. That's his case that they're working on. You see him come running in here, trying to cover for anybody. He didn't do that, to his credit. And then we come, before we end today, to Detective Mark Fuhrman. This man is an unspeakable disgrace. He's been unmasked for the whole world for what he is, and that's hopefully positive. His misdeeds go far beyond this case because he bespeaks a culture that's not tolerable in America. But let's talk about this case. People worry about this is not the case of Mark Fuhrman. Well, it's not the case of Mark Fuhrman. Mark Fuhrman is not in custody. He's not. That's the man who they're trying to put away with witnesses like this. A corrupt police officer who is a liar and a perjurer. You know, they were talking yesterday in their argument about, well, they said, well, gee, would you just think he would commit a felony? What do you think it was when he was asked the questions by F. Lee Bailey? So well put. And we'll talk about that at the very end, about whether he'd ever used the N-word in 10 years. And he swore to tell the truth. He lied, and others knew he lied. But what I find particularly troubling is that they all knew about Mark Fuhrman. And they weren't going to tell you. They tried to ease him by. Of all the witnesses who've testified in this case, how many were taken up to the grand jury room where they have this prep session? They ask him all these questions. Ms. Clark, and I went back and I read again her introduction of Mark Fuhrman. How many witnesses did they do that with? Well, they took him up there and they prepared him for this. Because you see, they knew about the Kathleen Bell letter. But she didn't fit. She didn't fit in what they wanted. They didn't want her. They'd rather malign her and believe this lying police officer. So they knew. Make no mistake about it. And so, when they try to prepare him, talk to him, and get him ready, and make him seem like a choir boy, make him come in here and raise his right hand as though he's going to tell you the truth and give you a true story here. He knew he was a liar and a racist. There's something about good versus evil. There's something about truth. Truth crushed to earth will rise again. You can always count on that. And so when Miss Clark so gently puts him on the stand and talks to him about, tell us how you feel about testifying today. Nervous? Okay. Reluctant? And all the things about this bad lady, Kathleen Bell. They brought it out at the beginning. This bad Kathleen Bell saying all these mean things about you. Oh, and you don't know her even, do you? We asked you to look at her on the Larry King show, and you didn't recognize her. You don't know her. Oh, well, it's just terrible, all these bad things are happening to you, Detective Fuhrman. You go back and you look at your notes of how the testimony was as they tried to bring him in here and pass him off. These things were all happening. The Kathleen Bell letter was in 85 and 86. Same time he went out to O.J. Simpson's house in 85 that they want to talk so much about. What they're talking about is not even relevant. What we're talking about now is what happened in this case. And so, after having made all these denials and been adopted and accepted by the prosecution and put him on the stand, and you saw it. You saw it. It was sickening. And then, my colleague Lee Bailey, who can't be with us today, but God bless him wherever he is, did his cross-examination of this individual. And he asked some interesting questions. Some of you probably wonder, well, gee, wonder why he's asking that. He asked this man whether or not he'd ever met Kathleen Bell. course, he lied about that. Never met this woman. I don't recognize her. I don't know her. Gee, I don't know anything about that. Boy, and he sounded really convincing, didn't he? He says, quote, I do not recognize this woman as anybody I have ever met. That's what he says. Then Bailey says, have you used that word, referring to the N-word, in the past 10 years? Not that I recall, no. You mean if you call someone a nigger, you have forgotten it? I'm not sure I can answer the question the way it's phrased, sir. And they go on. He says, Bailey then pins him down. I want you to assume that perhaps at some time since 1985 or 86, you addressed a member of the African-American race as a nigger. Is it possible that you have forgotten that act on your part? Answer, no, it is not possible. Are you therefore saying that you have not used that word in the past 10 years, Detective Furman? Answer, yes, that is what I'm saying. Question, and you say under oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Furman? That's what I'm saying, sir. So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar. Would they not, Detective Furman? Yes, they would. All of them? Correct? All of them. That's what he told you under oath in this case. Did he lie? Did he lie? Did he lie under oath? Did this key prosecution witness lie under oath? And I'm going to end this part and resume with him tomorrow morning. Did he lie? And when they try to tell you he's not important, let's remember this man. This is the man who was off this case shortly after 2 o'clock in the morning, right after he got on it. This is the man who didn't want to be off this case. This is the man, when they're ringing the doorbell at Ashford, who goes for a walk, and he describes how he's strolling. Let me quote him for you. Here's what he says. I was just strolling along, looking at the house. Maybe I could see some movement inside. I was just walking while the other 3 detectives were down there. And that's when he walks down. And he's the one who says the Bronco was parked askew. And he sees some spot on the door. He makes all of the discoveries. It's got to be the big man, because he's had it in for O.J. because of his views since '85. This is the man. He's the guy who climbs over the fence. He's the guy who goes in and talks to Cato Kalin while the other detectives are talking to the family. He's the guy who's shining a light in Cato Kalin's eyes. He's the guy looking at shoes and looking for suspects. He's the guy who's doing these things. He's the guy who says, I don't tell anybody about the thumps on the wall. He's the guy who's off this case, who's supposedly there to help this man, our client, O.J. Simpson, who then goes out all by himself. All by himself. Now, if he's worried about bodies or suspects or whatever, doesn't even take out his gun. He goes around the side of the house, and lo and behold, he claims he finds this glove. And he says the glove is still moist and sticky. Now, under their theory, at 10:45, that glove is dropped. How many hours is that? It's now after 6 o'clock. So what is that, 7.5 hours? It's a testimony about drying time around here. There's no dew point that night. Why would it be moist and sticky? Unless he brought it over there and planted it there to try to make this case. And there is a Caucasian hair on that glove. This man cannot be trusted. He is central to the prosecution. And for them to say he's not important is untrue. And you will not fall for it. Because as guardians of justice here, we can't let it happen. We'll see you tomorrow. Thank you, Your Honor.
All right. Mr. Cochran, can you have it taken down, please?
Yes, sir.
Thank you. Mr. Cochran, you may continue with your argument, sir. Good
Thank
morning.
you very kindly, Your Honor. Good morning, Judge Ito. Good morning again, ladies and gentlemen.
Good morning.
When we concluded last night, ladies and gentlemen, we had discussed a number of things, and I'm sure you have them very much in mind. To summarize some of the things that we talked about and put it in perspective, we talked about a police department who from the very beginning was more interested in themselves and their image, and that carried through. We talked about socks that appeared all of a sudden that weren't there, socks where evidence was planted on them. We talked about police officers who lie with impunity, where the oath doesn't mean anything to them. We talked about messengers, where you couldn't trust the message. We talked about gloves that didn't fit, a knit cap that wouldn't make any difference, a prosecution scenario that is unbelievable and unreasonable. In short, we talked about reasonable doubt. We talked about something that's made this country great, that you can be accused in this country of a crime. But that's just an accusation. And when you enter a not guilty plea, since the beginning of the time of this country, since the time of the Magna Carta, that sets the forces in motion and you have a trial. That's what this has been about. That's why we love what we do. An opportunity to come before people from the community, the consciences of the community. You are the consciences of this community. You set the standards. You tell us what's right and wrong. You set the standards. You use your common sense to do that. Your verdict goes far beyond these doors of this courtroom. As Mr. Darden said, the whole world is watching and waiting for your decision in this case. That's not to put any pressure on you. Just tell you what's really happening out there. So we talked about all of those things. Hopefully in a logical way. Hopefully something I said made some sense to you. Hopefully as an advocate, you know my zeal. You know the passion I feel for this. We've all got time invested in this case. But it's just not about winning. It's about what's right. It's about a man's life at stake here. So in voir dire, you promised to take the time that was necessary, and you have more than done that. Remember, I asked you, though, that when you got down to the end of the case, when you kept all your promises about coming here every day and taking these notes and paying attention and, you know, listening to us drone on and on and on, that pretty soon it would be in your hands. And then you couldn't just rush through that, could you? Now, we tried to make it a little more simple with regard to the issues, but still, we're going to have 12 minds coming together. 12 open minds, 12 unbiased minds to come together on these issues. And you will give it, I'm sure, the importance to which it's entitled. Please don't compromise your principles or your consciences in rendering this decision. Don't rush to judgment. Don't compound what they've already done in this case. Don't rush to judgment. Have a judgment that is well thought out. One that you can believe in the morning after this verdict. I want you to place yourself the day after you render the verdict. When you get up and you look in the mirror and you're free, you're no longer sequestered. You probably look for each other, but you know, you'll be happy to be home again. But what's important is, look in that mirror and say, have I been true to my oath? Did I do the right thing? Was I naive? Was I timid? Or was I courageous? Did I believe in the Constitution? Did I believe in justice? Did I do my part for integrity and honesty? That's the mission you're on in this journey toward justice. And now, yesterday I touched briefly on some of Mr. Darden's argument, and we talked a little bit about the fact of his contention about motive. We talked about his analogy about a fuse and I referred to him as Dr. Darden with regard to what he had to say. And I thought I just would summarize briefly this morning a response to what he had to say and what he tried to weave together. As I said, he talked about an incident in 1985, an unfortunate incident between two people who were married. There was no arrest. There was no physical violence. The one incident in 89, the one he's not proud of, the one he wrote those letters about, the one he apologized for and said he was sorry. And there is no physical violence after that. In the 1993 call, the 911 call, you listen to that entire tape. When they cut it off, you'll remember that it's unfortunate when anyone has an argument. But you listen carefully to what Mr. Simpson is arguing about, what he's talking about, and what the discussion is about. Mrs. Simpson mentions the children. And he says, you weren't worried about the children when you were doing so-and-so on the couch. It's pretty graphic, but any man or woman would be upset over what he's talking about on that tape. There was no physical violence. There's no excuse for him kicking the back door. But by the end, you remember what Cato Kalin said and what the police officer said. They resolved this matter. It was an argument. It was loud and raucous, and they moved on. There was no fuse after that. And this was during a time, you'll recall, that in January of 1992, when they first agreed to separate, you don't hear anything about a dispute. When Mr. Nicole Brown Simpson moved out, there was not any question about a dispute. When she got this divorce at the end of 92, there was no dispute. They're both dating other people. He's with Paula Barbieri for that like whole year. And then you know it wasn't Mr. Simpson who pursued Mrs. Simpson. It was her who wanted to get back with those kids. You heard Arnell Simpson, and then they agreed. But he put some provisos on that. She couldn't move back in that house. She still kept her own house. Now, who is controlling whom? Who is pursuing whom when he talks about fuse? There is no fuse. They get back together and they try to make it work. It lasts for almost a year. My learned friend has the dates all wrong. It's around Mother's Day when they break up. You remember, there's testimony from Cato Kalin about a pediatric AIDS affair where Paula Barbieri goes with O.J. Simpson. It's early part of May. After Mother's Day, after they break up, with the kids, Sidney and Justin. Now we know they'd been friends, even when they broke up, they're friends. You know how you know that? Remember the barber, Juanita Moore, nice lady who came in here and talked about O.J. Simpson not having dandruff, not having treated hair. She said she came to the house in the first part of May, and there was Nicole there, over at O.J. Simpson's house. There's no fuse. Then they go on later that month. They break up. Even after being broken up, what does Arnell tell you? That when Nicole gets sick, now these other people who she may be seeing or whatever, it's O.J. taking her soup, trying to help out. Now you do that for your ex-wife or your ex-boyfriend or whatever. There's no fuse. There's no strings attached to that. He goes on with his life because now he's back with Paula. We'd been with the year before, and he didn't. And Miss Clark tried to get Cato Kalin to ask, didn't he take Paula someplace in the summer of 93 when she knew they were now back together? And Cato says, no, I don't think so. Because they made this arrangement to date each other exclusively. And that's what happened, you see. And so we get all the way back past May into June. And there is no trigger, there is no fuse, there's nothing going on. The only fuse, the only trigger is in Mr. Darden's mind. The evidence isn't there, and they spent all this time about motive. There is none. They were two people who divorced. The case was settled, they had their homes, they moved on. Christian Reichardt tells you that night he was happier than he'd been for a long time because he got his life together and moved on. And so I just wanted you to put that in perspective. And if that wasn't enough, you look at that video of June 12th and the photograph of him with his daughter, and you see whether or not this is a happy man who's just getting on with his life. So when he rhetorically asked the question, why didn't we call Lenore Walker? I say back to him, why didn't you call Lenore Walker? She had something bad to say about O.J. Simpson. It wasn't necessary. It wasn't necessary. It wasn't necessary. As you know, we could be here forever, calling one witness after the other. Sooner or later, you were going to revolt, and I wouldn't blame you. Mr. Darden agrees. We had to cut it off at some point. So I hope that when you look about this so-called board of abuse and they have things about a divorce and things up there, you put this in perspective. Absence of motive tends to establish innocence. That's what the jury instruction says. Evidence of other offenses are introduced for a very limited portion in this case. And the bottom line is, the positive things in this man's life, the good days, far outweigh the bad days. And in your life, in all of our lives, we just hope at the end, when we must ultimately meet our makers, that the good days have outweighed the bad days. And in this marriage, the lasting monuments and memorials to this marriage are these two beautiful children. They had more good days than bad days by all of the evidence. These two people loved their children. They may have gone separate ways, but they loved their children. That's why he was back in town to go to that recital where there's so many people, where it's in this auditorium where Nicole Brown Simpson gets his tickets. You know, that's why they're talking in the afternoon, to make arrangements. And she's the one who holds a seat for him. This is what happened on that date. This isn't about any argument. This is a family thing. So Mr. Darden wants to make a big thing and says, well, he had to go out to dinner with Cato. He had to catch a plane. See the evidence for what it is. Understand these things. Put them in perspective. And so, you use your common sense. There is no fuse with regard to that. It's important for you to know that. Take a look at that video when you're back there. Take a look at all of the evidence. In this case, Ms. Clark, in her argument on several occasions, said that Mr. Simpson was cut on his razor-sharp cell phone. Well, it's not what the evidence is it? It's not what was said. I read you what Dr. Batten said about that. And so we can use these words, but let's hopefully be accurate as we try to say those things. Now let's go back to where we were when we broke last night. We had started talking about the messengers in this case. We talked briefly about Van Atter and about all of his big lies. His lies become very important because he's the co-lead investigator in this case. From the very beginning, he was lying to you. And it was interesting. When I thought about this last night after I left you, just about 10 days ago, a week or 10 days ago, Van Atter took that stand again, and you saw him. You had a chance to again observe his demeanor, and you're smart. You know when somebody's lying and not telling you the truth. I mean, I don't have to go into that. You know, you don't need the jury instruction. You got this visceral reaction. You got your experiences in life, and you know somebody who's lying. But, you know, he said something really interesting. It was really preposterous when you think about it. He said, Mr. Shapiro, Mr. O.J. Simpson was no more a suspect than you were. Now, who in here believed that? Did he really think he's going to come back in here and we were going to believe that O.J. Simpson was no more a suspect than Robert Shapiro? That's what he told you. Big lies. You can't trust him. You can't believe anything that he says because it goes to the core of this case. When you're lying at the beginning, you'll be lying at the end. The book of Luke talks about that. It talks about if you're untruthful in small things, you should be disbelieved in big things. There's no question about that. We've known that all along. So this man, with his big lies, and then we have Furman coming right on the heels, and the two of them need to be paired together because they are twins of deception. Furman and Van Atter twins of deception who bring you a message that you cannot trust. That you cannot trust. Let's continue on where we left off then with this man, Furman, who says some very interesting thing in the course of his testimony. And as we talked about Van Adder's big lies, we have Furman's big lies. The Van Adder, the man who carried the blood. Furman, the man who found the glove. You recall that he was asked, as I read to you yesterday briefly, the question well phrased by Lee Bailey, have you ever used this N-word in 10 years? And went right back to 85. And he picked that 85 date. You know why? Because of the Kathleen Bell letter. Just like they knew about it. Picked that date. So he knew he was lying. Honed in on him. You know, liars can be tricky. And so he was, at that point, trying to pin it down for you. 10 years. 85 to 95. This was like in February of this year. Says also he never met Kathleen Bell, this Marine Center. Tells you that Rokar, the photographer, took this photograph after 7 o'clock in the morning. I remember that. Look back through your notes. And the reason he tells you that is because he wants that photograph of him pointing at the glove taken after he supposedly finds the glove at Rockingham. Now, you may not have caught that right at the beginning when this was happening. He says he took the photograph at Rockingham after 7 o'clock a.m. after they returned from Rockingham. You know, they all go over to Bundy after 5 o'clock. Strike that. At Bundy, they all go over to Rockingham at 5 o'clock from 5 to 7. And so it becomes very, very important as we look at this photograph in a few minutes. Rokar then comes here near the end of the case. There's been nobody called to refute him in rebuttal. It says, these photographs on this contact sheet are all taken while it's dark. He says he could tell the difference in a photograph taken an hour and a half before sunrise, 5:41, 5:42, and an hour and a half afterwards. So then why then is this big liar in the crime scene with access to the glove and the hat? Why is he down there pointing at this glove where he's walking and all in the blood and everything when he wants you to believe it's 7 o'clock? Now we know it's not 7 o'clock. See that photograph up there? That is Mark Furman pointing, you see the envelope? Pointing under this neatly arranged cap and glove supposedly just happened to fall right under that bush in that fashion. That's what you're asked to believe. There he is pointing at it. Well, now, let me tell you why this is important. You recognize Furman. Personification of evil. When he's doing that, he's trying to tell you this is some important piece of evidence here. And I just came back from Rockingham. This matches the glove found over there. That's what he tells you. But he's lying again. He's lying, and that's why he's central to this case, because he hadn't even been to Rockingham at that point, and he's tracking in that blood at that point. And that becomes very important, because you remember he slips up and says, in the Bronco at some point. Did he get in that Bronco? Did he put a bloody footprint in that Bronco? Are his shoes size 12? Talks about in the Bronco. He talks about them. Remember, there was a question he was asked about gloves, and Lee Bailey asked him about, well, he says, well, he's talking about gloves, and he says, them. Never explained that. When he says them, does that mean two gloves? He said, I saw them. Is that two gloves? Why would you say them? He's intelligent enough to come and lie to you. So, that picture, that photograph there, that seals their doom. That seals their doom. This man, who in 85, in his mind, started this. This man, who's asked to go over and help O.J. Simpson, to notify him and take care of the kids. This man, this perjurer, this racist, this genocidal racist, this is the man. And he says then, inferentially he didn't plant the glove, but now we know about these photographs when they were taken. And you look, you'll have that contact sheet, and you'll see the photograph of Miss Nicole Brown Simpson. And the last two on this roll, taken at nighttime with the flash. at 4:30 or so in the morning. Why else is this important? Because they're going to tell you, well, he didn't have an opportunity to get the glove or get access to anything. Remember, they brought all these police officers in here, including Lieutenant Spangler, to say, well, you know, we were just watching Furman the whole time. First of all, you knew that was a lie at the beginning. Why would anybody be necessarily watching him? They're always covering for him anyway. But we knew that wasn't true because when Rokar got there, shortly after 3 o'clock, Rokar goes to that back alley and he sees Risky, who's back there then. Remember, Rokar sees Risky in the back alley. Rokar doesn't even see Furman for like a half hour after he gets there, he says. Then all of a sudden, Furman shows up. Where has he been? What's he been doing? And then Risky is out in the front of Bundy there. And Risky testifies about the taking of this photograph. He wants to place the time later, but he said it's before the sun comes up, before daylight. That has to be, because we've stipulated to it, before 5:41. So inadvertently, he corroborates Rokar. But Rokar knows because he took these photographs. Why then, ladies and gentlemen, is he pointing at this glove when he hasn't even been over there? Why then would they try to tell you he doesn't have time at Bundy when he's by himself for this period of time? He's not with any Spangler, he's walking around by himself. Why then is he walking in that crime scene, and why does he lie to you and said he didn't have access to the crime scene? Now these are the facts. These are the facts. I haven't made them up. This is what you heard in this case. This is what we've proven. Some of it came in late, some of it came in early. But our job here is to piece this together so that you can then see this. So when he refers to the gloves as them, that's never been cleared up for you, and it can't. It's a Freudian slip. When he talks about in the Bronco, and there was a dispute, well, did he really say that? Remember, the tape was played, the preliminary hearing, and his voice was heard saying, in the Bronco. You can see all these things. He's strolling down to Rockingham. The big man, figuring a way to do this, to carry out this plan, this thought he has in his mind since 1985, to make the big score. And so Rokar severely impeaches Furman about these photographs. And once again, these photographs speak 1,000 words. Concluding about Risky, he said on cross-examination that the photograph pointing at the glove was taken at least 40 minutes before daylight. The sun rose at 5:41, maybe a little bit late, but it was before daylight. And so we know that. That's now clear. Why did they then all try to cover for this man, Furman? Why would this man, who is not only Los Angeles' worst nightmare, but America's worst nightmare, why would they all turn their heads and try to cover for him? Why would you do that if you're sworn to uphold the law? There is something about corruption. There's something about a rotten apple that will ultimately infect the entire barrel. Because if the others don't have the courage that we've asked you to have in this case, people sit silently by. We live in a society where many people are apathetic. They don't want to get involved. And that's why all of us, to a person in this courtroom, have thanked you from the bottom of our hearts. Because you know what? You haven't been apathetic. You're the ones who made a commitment toward justice. And it's a painful commitment. But you got to see it through. Your commitment, your courage, is much greater than these police officers. This man could have been off the force long ago if they'd done their job, but they didn't do their job. People looked the other way. People didn't have the courage. One of the things that has made this country so great is people's willingness to stand up and say, that's wrong. I'm not going to be part of it. I'm not going to be part of the cover-up. That's what I'm asking you to do. Stop this cover-up. Stop this cover-up. If you don't stop it, then who? You think the police department is going to stop it? You think the DA's office is going to stop it? Do you think we can stop it by ourselves? It has to be stopped by you. And you know, they talked about Furman. They talked about him in derisive tones now. And that's very fashionable now, isn't it? Everybody wants to beat up on Furman, the favorite whipping boy in America. I tell you, I don't take any delight in that. Because you know, before this trial started, if you grow up in this country, you know there are Furmans out there. You learn early on in your life that you're not going to be naive, that you love your country, but you know it's not perfect. So you understand that. So it's no surprise to me. But I don't take any pride in it. But for some of you, you're finding out the other side of life. You're finding out. That's why this case is so instructive. You're finding out about the other side of life. That things aren't always as they seem. It's not just rhetoric. It's the actions of people. It's the lack of courage and it's the lack of integrity at high places. That's what we're talking about here. Credibility doesn't attach to a title or position. It attaches to the person. So the person who may have a job where he makes $2 an hour can have more integrity than the highest person. It's something from within. It's in your heart. It's what the Lord has put there. That's what we're talking about in this case. And so why don't they speak out? Why do they take him to their breast? Compare how our prosecutors treat Furman as opposed to Cato Kalin. Look at how they treated Mark Partridge as opposed to Cato Kalin. Look at how they embraced him. And now they want to distance themselves. These same people say, oh, he's not important. But the Rokar photograph puts the lie to that. He is very important. And what becomes so important when we talk about these two twin demons of evil, Van Adder and Furman, is the jury instruction, which you know about now. And it says essentially that a witness willfully false. I think Mr. Douglas is going to put that up for us. A witness willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely to a material point unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars. Why is this instruction so important? We got the bullet points up there. First of all, both prosecutors have now agreed that we have convinced them, beyond a reasonable doubt, by the way, that he's a lying, perjuring, genocidal racist. And he's testified willfully false in this case on a number of scores. That's what his big lies tell you. And when you go back in the jury room, some of you may want to say that, well, gee, you know, boys will be boys. This is just like police talk. This is the way they talk. That's not acceptable as the consciences of this community. If you adopt that attitude, that's why we have this. Because nobody has had the courage to say it's wrong. You are empowered to say we're not going to take that anymore. I'm sure you'll do the right thing about that. So that what you then, it seems to me, must do is you have the authority. You may reject the whole testimony. You can then wipe out everything that Furman told you, including the glove and all the things he recovered in the glove. That's why they're so worried. That's why when people say Furman is not central, they're wearing blinders. They've lost their objectivity. They don't understand what they're talking about. It's embarrassing for learned people to say that, but they're entitled to their opinions, but we're going to speak the truth in a courtroom. You are supposed to speak the truth. A witness who walks through those doors, who raises his or her hand, swears to tell the truth. You've heard lie after lie
after lie that's been exposed. And when a witness lies in a material part of his testimony, you can wipe out all of his testimony as a judge of the facts. That's your decision again. Nobody can tell you about that unless you feel that the greater probability of truth lies in something else they said. Wipe it out. This applies not only to Furman, it applies to Van Adder, and then you see what trouble their case is in. Because they lied to get in there to do these things. When Van Adder carries that blood, they can't explain to you why he did that. Because they were setting this man up. And that glove, anybody among you think that glove was just sitting there, just placed there, moist and sticky after 6.5 hours. The testimony is it would be dried in 3 or 4 hours, according to McDowell. We're not naive. You understand. There's no blood on anything else. There's no blood trail. There's no hair and fiber. And you get the ridiculous explanation that Mr. Simpson was running into an air conditioning on his own property. So,
anybody else?
Witness is willfully false. One material part distrusted in others. These two form basically the cornerstone of the prosecution's case. Now, you know, people talk all the time, well, you know, you're being conspiratorial and whatever. Gee, why would all these police officers set up O.J. Simpson? Why would they do that? I'll answer that question for you. They believed he was guilty. They wanted to win. They didn't want to lose another big case. That's why they believed he was guilty. These actions rose from what their belief was. But they can't make that judgment. The prosecutors can't make that judgment. Nobody but you can make that judgment. So when they take the law into their own hands, they become worse than the people who break the law because they are the protectors of the law. Who then polices the police? You police the police. You police them by your verdict. You're the ones who send the message. Nobody else is going to do it in this society. They don't have the courage. Nobody has the courage. You have a bunch of people running around with no courage to do what is right. Except individual citizens. You're the ones in war. You're the ones who are on the front line. These people set policies. These people talk all this stuff. You implement it. You're the people. You're what makes America so great. Don't you forget it. And so, understand how this happened. It's part of a culture of getting away with things. It's part of a culture looking the other way. Of we determine the rules as we go along. Nobody's going to question us. We're the LAPD. And so you take these two twins of deception. And if, as you can, under this law, wipe out their testimony, the prosecutors realize their case then is in serious trouble. From risky to bushy. They came together in this case because they want to win. But it's not about them winning. It's about justice being done. They'll have other cases. This is this man's one life that's entrusted, or will be soon, to you. So when we talked about this evidence being compromised, contaminated, and corrupted, some people didn't believe that. Have we proved that? Have we proved that it was compromised, contaminated, and corrupted? And yes, even something more sinister? I think you'll agree we did. But there's something else about this man, Furman, that I have to say before I'm going to terminate this part of my opening argument and relinquish the floor to my learned colleague, Mr. Barry Scheck. It's something that Furman said, and I'm going to ask Mr. Douglas and Mr. Harris to put up that Kathleen Bell letter. You know, it's one thing, and I dare say that most of you, when you heard Furman say he hadn't used the N-word, that you probably thought, well, he's lying. We know that's not true.
That's just part of it, and that's what the prosecutors want to just talk about, that part of it. It's not the part that bothers us on the defense. I live in America. I understand. I know about slights every day of my life. But I want to tell you about what is troubling, what is frightening, what is chilling about that Kathleen Bell letter. Let's see if we can see part of it. And I think you will agree. So I want to put the focus back where it belongs on this letter and its application to this case. You'll recall that God is good, and He always brings you a way to see light when there's a lot of darkness around. And just through chance, this lady had tried to reach Shapiro's office, couldn't reach it. And in July of 1994, she sent this fax to my office, and my good, loyal, and wonderful staff got that letter to me early on. And this is one you just couldn't pass up. Get a lot of letters, but you couldn't pass this one up because she says some interesting things. And she wasn't a fan of O.J. Simpson. What does she say? I'm writing to you in regards to a story I saw on the news last night. I thought it ridiculous that the Simpson defense team would even suggest that there might be racial motivation involved in the trial against Mr. Simpson. Yes, there are a lot of people out there who thought that at that time. And you know, you can't fault people for being naive. But once they know, if they continue to be naive, then you can fault them. That's what it is, and that's why this case is important. Don't ever say again in this county or in this country that you don't know things like this exist. Don't pretend to be naive anymore. Don't turn your heads. Stand up. Show some integrity. And so I then glanced up at the television and was quite shocked to see that Officer Furman was a man that I had the misfortune of meeting. You may have received a message from your answering service last night that I called to say that Mr. Furman may be more of a racist than you could even imagine. I doubt that, but at any rate, it was something that got my attention. Between 1985 and 1986, I worked as a real estate agent in Redondo Beach for Century 21 Bob Maher Realty, now out of business. At the time, my office was located above a Marine recruiting center off of Pacific Coast Highway. On occasion, I would stop in to say hello to the two Marines working there. I saw Mr. Furman there a couple of times. I remember him distinctly because of his height and build. You know, he's tall. While speaking to the men, I learned that Mr. Furman was a police officer in Westwood. Isn't that interesting? Just exactly the place where Laura McKinney met him. And I don't know if he was telling the truth, but he said that he'd been in the special division of the Marines. I don't know how the subject was raised. But Officer Furman said that when he sees a nigger, as he called it, driving with a white woman, he would pull them over. I asked, what if he didn't have a reason? And he said that he would find one. I looked at the two Marines to see if they knew he was joking, but it became obvious to me that he was very serious. Now let me just stop at this point. Let's back it up a minute, Mr. Harris. Pull it back down, please. If he sees an African American with a white woman, he would stop them. If he didn't have a reason, he'd find one or make up one. This man will lie to set you up. That's what he's saying there. He will do anything to set you up because of the hatred he has in his heart. A racist is somebody who has power over you, who can do something to you. People can have views, they keep them to themselves. But when they have power over you, that's when racism becomes insidious. That's what we're talking about here. He has power.
A police officer in the street, a patrol officer, is the single most powerful figure in the criminal justice system. He can take your life. Unlike the Supreme Court, you don't have to go through all these appeals. He can do it right there and justify it. And that's why this has to be rooted out in the LAPD and every place else. Make up a reason. Because he made a judgment. That's what happened in this case. They made a judgment. Everything else after that was going to point toward O.J. Simpson. They didn't want to look at anybody else. Mr. Darden asked, who did this crime? That's their job as the police. We've been hampered. They turned down our offers for help. But that's the prosecution's job. The judge says, we don't have that job. The law says that. We'd love to help do that. Who do you think wants to find these murderers more than Mr. Simpson? But that's not our job. It's their job. And when they don't talk to anybody else, when they rush to judgment in their obsession to win, that's why this became a problem. This man had the power to carry out his racist views. And that's what's so troubling. Let's move on. Making up a reason. That's troubling. That's frightening. That's chilling. But if that wasn't enough, the thing that really gets you, she goes on to say, Officer Furman went on to say that he would like nothing more than to see all niggers gathered together and killed. He said something about burning them or bombing them. I was too shaken to remember the exact words he used. However, I do remember that what he said was probably the most horrible thing I'd ever heard someone say. What frightened me even more was that he was a police officer, sworn to uphold the law. And now we have it. There was another man not too long ago in the world who had those same views, who wanted to burn people, who had racist views and ultimately had power over people in his country. People didn't care. People said he's just crazy, he's just a half-baked painter. They didn't do anything about it. This man, this scourge, became one of the worst people in the history of this world, Adolf Hitler. Because people didn't care, didn't try to stop him. He had the power over his racism and his anti-religionism. Nobody wanted to stop him, and it ended up in World War II. The conduct of this man. And so, Furman was to take all black people now and burn them or bomb them. That's genocidal racism. Is that ethnic purity? What is that? What is that? We're paying this man's salary to espouse these views. You think he only told Kathleen Bell, whom he just had met? You think he talked to his partners about it? You think his commanders knew about it? You think everybody knew about it and turned their heads? Nobody did anything about it. Things happen for a reason in your life. Maybe this is one of the reasons we're all gathered together here this day. 1 year and 2 days after we met. Maybe there's a reason for your purpose. Maybe this is why you were selected. There's something in your background and your character that helps you understand this is wrong. Maybe you're the right people at the right time, at the right place to say no more. We're not going to have this. This is wrong. What they've done to our client is wrong. This man, O.J. Simpson, is entitled to an acquittal. You cannot believe these people. You can't trust the message. You can't trust the messengers. It is frightening. It is quite frankly frightening. And it's not enough for the prosecutors now to stand up and say, oh, let's just back off. The point I was trying to make, they didn't understand that it's not just using the N-word. Forget that. We knew he was lying about that. Forget that. It's about the lengths to which he would go to get somebody black and also white if they're associated with black. That's pretty frightening. It's not just African Americans. It's white people who would associate or deign to go out with a black man or marry one. You're free in America to love whomever you want. So It infects all of us, doesn't it? This one rotten apple. And yet they cover for him. Yet they cover for him. And so, how do we do it? And what do we do with regard to this man? Well, we call some witnesses. And you recall these witnesses. And before I talk about these witnesses just briefly, and I'm going to conclude my remarks with regard to them, I indicated to you that by the nature of this case, I'm going to pass the baton to Mr. Barry Scheck. You've been great from a standpoint of listening and watching, and I stayed longer than I planned to, but I hope you agree that some of these things were important. And I'll get one more time to conclude with some concluding remarks after Mr. Scheck finishes. The good news is that Mr. Scheck and I will both hopefully finish the day and turn it back over to Ms. Clark, so in a day or so you're going to get this case. You have to hear lawyers talk anymore. Be time to hear you talk. Time to hear you speak out. And I'll be happy. I'll relax tonight, knowing that soon it's going to be in your hands. We're real comfortable about that, all of us, and you should know that. So please give Mr. Scheck the attention that you've given me, and understand that all parts of this case are very important, and it all ties together, because it's all of the evidence in this case went through that LAPD and that black hole over there, that cesspool of contamination, and you listen to him about what he has to say in that regard. Mr. Darden said that in a textbook fashion, we had impeached Mr. Furman. Well, we thank him for that. We take no pride in that, but that's what did happen. In addition to calling Kathleen Bell where you saw her, and she's not the kind of lady that, you know, in looking at it, you probably remember her. Unless, you know, it'd be very interesting. You know he's lying about not knowing her. But this man used these words and these racial epithets so much, he probably can't remember who he said it to. He said it to everybody, whoever came in contact with him, on tape. Can you imagine the gall about that? That you would have these racist views, and yet you would put it on tape. Thank God he put it on tape. And so Kathleen Bell came in here and told you the same things in those letters. You saw her. You observed her. You know she told us the truth. They couldn't mess with her because now we had those tapes. And then there was Natalie Singer. Barely knew this man. He was dating her roommate. This man is an indiscriminate racist. He talks so bad that she didn't want him back in the house. What does he say to her? In her presence, the only good nigger is a dead nigger. Now that, probably all heard that expression sometime in your background or somewhere, or heard somebody say that, and that's tremendously offensive. He just says it in the presence of his partner's girlfriend, like they're going to go on a date. I mean, I hope that in the homes throughout this country, people aren't acting like this. This happened to come to light, but I'd be pretty frightened if I felt that the majority of people in this country acted like this behind closed doors or whatever, because what you do in the dark is going to come to the light. Remember that. That's what this case is about. It came to the light, and just in time to get it to you. So you saw her on the stand. You saw her graphically. Talk about that. Are you doubting anybody's mind? He's telling you the truth? Any one of you think she's not telling you the truth? And then finally we had Roderick Hodge in this series of witnesses. And Roderick Hodge, intelligent young man, understood something about his rights too. Because after this run-in with Furman and his partner, when he's in the back of the police car, Furman turns around and says to him words that I want you to remember in this case. I told you I'd get you, nigger. That's what he tells Roderick Hodge. Why is that important? Because from 1985, when he went on that one call involving the Mercedes, that was this man's mindset vis-a-vis O.J. Simpson. I'm going to get that guy. And in '89, when he wrote that report,
indelibly impressed on his mind. And in '94, he had his chance. Still in West Los Angeles, he had his chance. So Hodge is important because you can espouse all these epithets and talk theoretically about your racism, but when it's directed toward a human being. And I said to him, Mr. Hodge, tell this jury how that made you feel. He said it made me feel angry and upset and frustrated. It was dehumanizing in a free society. But this man, Furman, does it with impunity. And his partner sat there and heard it and didn't report it. There's something rotten about this kind of conduct. And it's gone on too long. And so, that's why he's important. But the capper was finding those tapes. Something that you could hear, lest there be any doubt in anybody's mind. Laura McKinney came in here, and I can imagine the frustration of the prosecutors. They've had the glove demonstration. They've seen all these other things go wrong. And now they got to face these tapes. And they didn't know how to handle her. Quite frankly, she was a reluctant witness. You know that. Mr. Darden asked her those questions where he became negative with her. But she's very smart. Unlike some others who didn't know how to handle it, she says, why are we having this negative conversation? Why are you acting and treating me like this? I didn't try to stop him about cover-ups and things. Why are you asking me these questions? I'm the one who's here on the subpoena. Why are you treating me like this? Now, you know it's true because they've heard the tapes. Why are you messing with this lady? You just get so wrapped up in what you're doing, I guess. Why are they messing with this lady? We owe a debt of gratitude to this lady. That ultimately and finally she came forward. And she tells us that this man, over the time of these interviews, uses the N-word 42 times, is what she says. The so-called Furman tapes. And you, of course, had an opportunity to listen to this man and espouse this evil, this personification of evil. And so I'm going to ask Mr. Harris to play Exhibit 1368 one more time. There was a transcript. This was not on tape. The tape had been erased, where he said, "We have no niggers where I grew up." These are 2 of 42, as you recall. And then there was his actual voice.
They don't do anything. They don't go out and initiate contact with some 6
Now, you heard that voice. No question whose voice that is. Mr. Darden concedes whose voice that is. They don't do anything. Talking about women. Doesn't like them any better than he likes African Americans. They don't go out and initiate contact with some 6'5" nigger who's been in prison pumping weights. That's how he sees the world. That's this man's cynical view of the world. That's this man who's out there protecting and serving us. That's Mark Furman. And he's paired in this case with Phil Van Adder. They're both beacons that you look at and look to as the messengers that you must look through and pass. They're both people who've shown that they lie, will lie, did lie on the stand under oath. And you know, one little parenthetical thing, how these people all try to stick together from a standpoint of law enforcement. The FBI agent comes in here and he talks about, when I bring out the fact that he says that Van Adder says they're not there to save lives on cross-examination, he says, well, he says, I think he was being sarcastic. That Van Adder was being sarcastic. Or maybe it was a joke. But, you know, when I listened to that, I thought about that and I said, what's the joke? What's the sarcasm? Is the Constitution, this man's rights to be safe and secure in his home, is that the joke? Is that the sarcasm? It's a sad state of affairs. That's the lead detective I'm talking about. These two twin devils of deception. and think about them and keep them in mind. Thank you for your attention during this first part of my argument. I hope that during this phase of it, I have demonstrated to you that this really is a case about a rush to judgment, an obsession to win at all costs, a willingness to distort, twist, theorize in any fashion to try to get you to vote guilty in this case where it is not warranted. That these metaphors about an ocean of evidence or a mountain of evidence is little more than a tiny, tiny stream, if at all, that points equally toward innocence. That any mountain has long ago been reduced to little more than a molehill under an avalanche of lies and complexity and conspiracy. This is what we've shown you. And so, as great as America is, we have not yet reached the point where there's equality in rights or equality of opportunity. I started off talking to you a little bit about Frederick Douglass and what he said more than 100 years ago. For there are still the Mark Furmans in this world and in this country who hate and are yet embraced by people in power. But you and I, fighting for freedom and ideals and for justice for all, must continue to fight to expose hate and genocidal racism and these tendencies. We then become the guardians of the Constitution, as I told you yesterday. For if we as the people don't continue to hold a mirror up to the face of America and say, this is what you promised, this is what you delivered. If you don't speak out, if you don't stand up, if you don't do what's right, this kind of conduct will continue on forever. And we'll never have an ideal society, one that lives out the true meaning of the creed of the Constitution, of life, liberty, and justice for all. I'm going to take my seat, but I get one last time to address you, as I said before. This is a case about an innocent man wrongfully accused. You've seen him now for a year and 2 days. You observed him through the good times and the bad times. Soon, it'll be your turn. You have the keys to his future. You have the evidence by which you can acquit this man. You have not only the patience, but the integrity and the courage to do the right thing. We believe you'll do the right thing. And the right thing is to find this man not guilty of both of these charges. Thank you very, very much. I appreciate your attention. I think, Your Honor, we may need a brief break because he has to be...
Exhibits.
Judge.
All right, ladies and gentlemen, we'll take a 15-minute recess at this time. Remember all my admonitions to you. We'll see you back here in 15 minutes. All right, we'll stand in recess.
Television viewers have seen a ringing and eloquent statement from defense attorney Johnnie Cochran, but there was much going on in the courtroom that the camera did not show. Dan Abrams was inside the courtroom. He's standing by. Dan, tell us about it.
Well, Fred, you'll remember that earlier, about 25 minutes ago, maybe 35 minutes ago, we took a break in the middle of Johnnie Cochran's closing argument. The reason we stopped is because one of the jurors was crying, and she walked out of the courtroom, went into the back, and then came back in. But even after she returned, she was given tissues by the sheriff's deputy. She was consistently wiping her eyes throughout Johnnie Cochran's discussion of Mark Furman. This is an African-American woman, someone who really in the past has not shown much emotion, not someone who generally seems to react to much of the testimony. And so I was certainly surprised when she had to run out of that courtroom. Everyone's eyes focused on Johnnie Cochran's eyes. He had the complete attention of this jury, but he also had the attention of the Goldman family. The Goldmans were furious as they came out of the courtroom, and in fact we're expecting them to hold a press conference downstairs at any moment. Fred Goldman was just fuming as we walked out. Something else from inside that courtroom, Fred, is that Detective Tom Lang, as you may have seen on camera, was sitting right next to Johnnie Cochran. I mean, he is literally a foot from Johnnie Cochran as Johnnie Cochran was delivering his closing argument. And this must have been intentional. After Johnnie Cochran attacked his partner yesterday, they are now forcing Johnnie Cochran to effectively say this to Tom Lang's face. And today, Johnnie Cochran went even further, calling Detective Van Adder and Detective Mark Furman the twin evils of deception, and really going after Van Adder in a way that we hadn't heard him go after it, and today he had to do it in front of his partner. The racism in this case is simply unacceptable. We heard Johnnie Cochran at one point say he is entitled to an acquittal.
Dan,
but the Goldmans are
pardon me, Dan Abrams, sorry to interrupt you, but that press conference has started. This is Fred Goldman, the father of Ron Goldman, one of the murder victims.
Nearly 40 minutes out of an hour, we have seen a man who perhaps is the worst kind of racist himself, someone who shoves racism in front of everything, someone who compares a person who speaks racist comments to Hitler, a person who murdered millions of people. This man is the worst kind of human being imaginable. He compares racism of its worst kind in this world to what's going on in this case. He has suggested that racism is the foundation of the police department, of our justice system, and only these jurors are capable of fixing everything that has been going on in history? This man is sick. He is absolutely sick. He walks around for the past days screaming, if you would, in a silent way that his life has been threatened. And who does he choose to walk with? Guards from the Nation of Islam. He's talking about racism, and he talks about hate. Who does he connect himself with? This man is a horror walking around amongst us, and he compares what Mark Furman did to misery from the beginnings of history. This man ought to be ashamed of himself to walk amongst decent human beings. This man is a disgrace to human beings. No. He is one of the most disgusting human beings I have ever had to listen to in my life. He suggests that racism ought to be the most important thing that any one of us ought to listen to in this court, that any one of us in this nation should be listening to. And it's because of racism we should put aside all other thought, all other reason, and set his murdering client free. He's a sick man, and he ought to be put away. He's a disgusting human being.
And if ever there needed to be an illustration of the deep passions that have been stirred by the O.J. Simpson case, Fred Goldman, the father of Ron Goldman, with a virulent attack on defense attorney Johnnie Cochran, accusing him of the deepest kind of racism. Judge Lancito is speaking, indicating that the jury is in place.
Address the DNA issues or physical evidence issues.
I would say.
You may proceed.
Ladies and gentlemen of the jury, good morning. Let me join with everybody in thanking you for your service. The frustration, the loneliness, the sacrifice you've made in this sequestration is something that we understand, or we're trying to understand. As the judge has pointed out a number of times, my colleague, Mr. Neufeld, and I, we're from New York City, more specifically, we're from Brooklyn. And we've been out here quite unexpectedly for a lot of months. And I remember when that detective from Chicago testified about having those keys that you stick in and out of the doors and little lights go on. Every day, going in and out of those doors, again and again and again, like Groundhog Day, everything repeating itself, the monotony, the loneliness, the frustration. We sit around, we talk sometimes in amazement at how you deal with this and how appreciative we are. And, well, it's just really an honor and a privilege to present this case to you. And as lawyers that dealt with some of the forensic evidence in this case, which was detailed and complicated, and I'm sure I speak for myself, Mr. Blazier, Mr. Neufeld, Mr. Clark, for the prosecution, Mr. Goldberg, that we had a job. Our job was to make it simple, to make it cogent without sacrificing any meaningful detail. That's our job. And I can't tell you how appreciative we are because you paid attention, you were patient, you followed the evidence. I know that, I watched it. Now, you know, it's our job to make it simple, to make it cogent without sacrificing detail that was important. And sometimes we let you down. I know that. Some days, when we were talking about some of this, it was hard, and we came back to it again, and I think both sides tried to clarify the issues as much as we could. But you never let us down, because those were long days, but you were more than fair with us. I know you followed and paid attention to this evidence. So it is a privilege and honor to have presented that evidence to you. And I must also say that standing before you right now is a terrifying responsibility. It's a terrifying responsibility because we think the evidence shows that we represent an innocent man wrongly accused. We think the prosecution hasn't come close to meeting its burden of proof in this case beyond a reasonable doubt. And we think that the integrity of this system... I'm sorry. What is this? The integrity of this system is at stake. You cannot convict when the core of the prosecution's case is built on perjurious testimony of police officers, unreliable forensic evidence, and manufactured evidence. It is a cancer at the heart of this case, and that's what this evidence shows. When you go through it patiently, when you go through it carefully, when you go through scientifically, logically, that's what the evidence shows. And you cannot convict on that evidence. There are many, many reasonable doubts buried right in the heart of the scientific evidence in this case, and we have demonstrated them. And we don't have to prove them, but the evidence shows it. So, in the words of Dr. Lee, something is wrong. Something is terribly wrong with the evidence in this case. You cannot trust it. It lacks integrity. It cannot be a basis for a verdict of beyond a reasonable doubt. There was a logo that we showed you in the opening statements that we've reproduced here on a board, and you may recall it. It's a black hole. As you recall, it shows the evidence from Bundy, the evidence from Rockingham and the Bronco, the evidence from Mr. Simpson itself, passes through the Los Angeles Police Department, the messengers that Mr. Cochran was talking about, the lab, criminalists, coroner's office, and then it is tested by the FBI, the Department of Justice, and so on. And if you recall in the opening statements, we said contaminated, compromised, and corrupted, integrity of the evidence. Now, the importance of this flow chart is point number one. And you heard Dr. Cotton, Gary Sims, Dr. Gerdes, all the forensic experts told you, with respect certainly to DNA testing, all the testing, if it is contaminated, compromised, or corrupted here, it doesn't matter what the results are by these other testing agencies. Because if it happens within that black hole of LAPD, it doesn't matter how many times you test it. Ms. Clark got up there and said, well, why didn't we hear from Dr. Blake, who, if we didn't have Dr. Blake in this case to be sitting there as the testing was going on while you were already serving on this jury panel, things were being tested. He was up there looking at what they were doing. If we didn't, we wouldn't have even known what was going on in this case. But the point is, by the time it reached the California Department of Justice and Gary Sims, if that evidence, and we've demonstrated, contaminated, compromised, and corrupted, you could do 100 tests. Dr. Blake could test it, Dr. Lee's lab could test it, everybody could test it, and you'd get the same result. So that has not been the issue in this case, and don't be distracted by that. Dr. Terry Speed, you recall him, he gave testimony in this case about error, laboratory error. And he again pointed out, he used that term common mode error. If it happens here, and that's where the evidence is compromised, contaminated, and corrupted, these results are not adding anything. So you ask the question, how did the Los Angeles Police Department, how does any laboratory become a black hole that impairs the integrity of the evidence? Can we have the first slide? Any laboratory has to have three things. You have to have rules and training, you have to have what's known as quality assurance, and you have to have chain of custody, security of the evidence. Well, what have we heard about rules and training at the Los Angeles Police Department laboratory? Well, this laboratory is run without a set of rules that everyone knows. They don't even have a manual. Think about that. That's extraordinary. And then they have this draft manual. And it's ignored by the criminalists. Fung and Mazzola, they don't know what's in the draft manual, what procedures there are. And then the laboratory director, Michelle Kessler. Well, she was the acting laboratory director. Actually, one of the real problems here is that at the time of this case, the head of the laboratory was a police officer, not a scientist. But Michelle Kessler, she had that draft manual on her desk for 4 years, going through it until she says, well, some of this is no good, and they didn't get around to it. So that's how you become a black hole. The testimony is clear in this case. They did not give their criminalists training in state-of-the-art techniques. In particular, of great relevance here, there was no DNA training for the evidence collectors. Now, that's got to be a significant point. Ms. Clark told you in the opening statement that collecting, preserving bloodstain evidence for purposes of DNA testing was as simple as going into your kitchen and cleaning up spillage. Now, we all know that's not true, based on what we've heard in this case. Can we have the next slide, please? Quality assurance. That's a term that's used in bureaucracies, in hospitals, and laboratories, any place where you're trying to deliver service with integrity. What is going on here? There is a failure to document how you collect the evidence. A fundamental duty, as Dr. Lee showed you, remember with that chart, fundamental duty of a criminalist to document the evidence. In other words, where it was picked up, how it was picked up, when it was picked up. And we have seen the problems in this case when you can't do that. And you try to reconstruct it later when your memories are gone and you can't do it. Well, that's not done. And failure to document testing is tolerated. Compare the notes at the Department of Justice, Gary Sims and Renee Montgomery, with what you saw from Colin Yamauchi and Dennis Fung. I had to rearrange the notes for Colin Yamauchi, his own notes, when he was on the witness stand, and he goes, that's right. First I took out O.J. Simpson's reference sample and made the Fitzgerald card. Then the next thing I did was the glove. And then the next thing I did, all within that 1 hour and 20 minutes, were the Bundy blood drops. I had to reconstruct his notes for him. And then he goes, that's right. That's the way it happened. I guess that's right. I mean, it had to be when you reconstructed it all. But the notes are not there. And that's fundamental for having any integrity whatsoever. There was no serious supervision of these people. That's just clear. You saw it. This lab was not inspected. This lab is not accredited. This lab is not subjected, certainly the DNA, to external blind proficiency testing, which you know is what you need. Dr. Gerdes told you about that. Everybody talked about that. This National Research Council report, DNA Technology and Forensic Science. Can we have the next slide? Now this is critical. Chain of custody and security. There is absolutely nothing more fundamental to preserving integrity, forensic evidence, than a chain of custody, than having security. You have to know what you're picking up. You have to be able to document it. Otherwise, bad things can happen and nobody can trace it. In this case, they did not count the swatches when they collected them. They did not count the swatches when they got back to the laboratory and put them in the tubes for drying. They did not count the swatches when they took them out of the tubes and put them in the bindles. We don't know how many swatches they started with. They didn't book the evidence in this case for 3 days. They kept it in the least secure facility, the evidence processing room, for 3 days without being able to track the items. The lead homicide detective in this case, and we've talked it about a little and we'll talk about it some more, is walking around with an unsealed blood vial for 3 hours. It's unheard of. The other lead detective in this case is taking shoes home. Right out of that, this could be critical evidence. The shoes that their suspect was wearing that night, taking it home. Now, you know, it was amazing when Mr. Fung testified, the extent to which, you know, they've lost all track of the rules. At one point I asked him, well, would it have been all right if they took the blood home? And he said, sure, you could put, as long as you put it in the refrigerator overnight. Do you remember that answer? I mean, there's no sense of what has to be done in order to give you reliable evidence. None. Think about the Bronco. They finished doing the collection in the Bronco, and then it's abandoned literally for 2 months. There's a box you're supposed to check off, give special care if you're going to collect it for biological evidence. Not checked off. It is sent to Vertel's. It is abandoned for 2 months. There are no records of who went in and out of that car. There was a theft. Anybody was allowed in there. And then on August 26th, they're collecting evidence from it. And then finally, and this is, can we have the next board? This is a critical point that I think demonstrates all you need to know about security and chain of custody in this laboratory. The missing lens. The missing lens. Now, this is very important evidence. This is the envelope that's found at the crime scene with the prescription glasses. If you're investigating a case, you're very concerned about this.
on this board?
No, there is not, Your Honor.
All right, thank you.
Now, we can tell, as Dr. Lee pointed out, on this lens, there are smears of blood, trace evidence. There could have been fingerprints from a perpetrator who was going into that envelope. On June 22nd, Dr. Baden and Dr. Wolf got an opportunity just to look at the evidence, not touch or examine or test, just to look. And they saw 2 lens there. Made a note of it. February 16th, think about it, that's the first time we got a chance to inspect and just even handle the evidence. You're already sitting here, February 16th, there's something wrong. When we look at it, that lens is gone. There is no report, no record, no investigation of its disappearance. Nobody comes in and tells you what happened. Now that tells you a lot. Did somebody take this from the laboratory as a souvenir? Did somebody walk off with this? How can that be? This is critical evidence in a case. How can that be? It just vanished down this black hole? Now they're going to say, we're Fort Knox. Nobody could get to the evidence in this case with our evidence tracking system. Now, I should just tell you in passing, I'm sure you caught it, that even when it's booked into the evidence control unit and it's supposedly being tracked, they didn't say their computer tracking system was a chain of custody system. It isn't. They'd have all the evidence item in boxes, like the sock and the blood drops, and they'll put them in the serology freezer, and they're in a box there. Then somebody will hit the computer and they can go in, and then they can take any item they want out of that box. It's not tracked by specific items. There is no good security in this system. There's plenty of access if you want to tamper with evidence, if you are authorized personnel, if you are a lead detective, if you are somebody there, it can happen. And the missing lens tells you all you need to know. What is going on here? And if they come back and say, well, maybe Dr. Baden and Wolf are wrong, there was no lens to begin with. Well, that's even weirder, isn't it? What kind of killer takes a souvenir like this? How does that fit in with their theory? The missing lens is a serious problem in this case. There's no compliance with the NRC report. There's no compliance with the kind of standards that you would require in a life and death situation. And this is a life and death situation. And that's what you have to demand of a laboratory. And Dr. Gerdes is a man that deals with life and death situations, bone marrow transplants, organ transplants, disease diagnosis. He came in and told you about the standards that we demand, that we require, that ought to be the minimum. They're not close. You can't brush this off, as Ms. Clark did in her arguments, by saying, sloppy criminalists, sloppy coroner. And that's all she said. I fully anticipate that most of the matters I'm going to be addressing to you, she's been planning to address in her rebuttal summation, because she certainly didn't address them in her closing argument, did she? You can't just say sloppy criminalist, sloppy coroner, big deal. She said DNA, it's an insult to your intelligence, frankly. DNA is used to identify the war dead. Therefore, accept all the evidence in this case. That doesn't answer the question, does it? As a matter of fact, the DNA tests she's talking about are something they call mitochondrial DNA tests. It has nothing to do with the tests in this case. And the war dead has nothing to do with what was going on in this case. Zero. It's not an answer. It's not this case. It's not the techniques. They argue that defense has to prove exactly how, exactly where, exactly when tampering occurred with any of this evidence. That's not our burden. They have to prove to you that this evidence has integrity beyond a reasonable doubt. And you know, when people tamper with evidence, they don't do it on videotape. They try to do it with some stealth. They try to cover their tracks. And as Mr. Cochran's pointed out, and if you think about this evidence, it wouldn't take more than 2 bad police officers to do this. And a lot of people look the other way. We don't have to prove anything. And we don't have the burden of proof here. And I'm going to confront each and every one of these essential pieces of evidence in this case and raise a reasonable doubt about it, more than a reasonable doubt, many reasonable doubts. But if they fail in one of their essential facts, you have to acquit. We're going to go through the socks. Another reason I put this up here is that you'll know when I'm getting close to done. And you can follow along. The socks, the stains on the back gate, the missing blood, the hair and fiber, the evidence of struggle at Bundy, the testimony of Dr. Batten and Dr. Lee, the Bronco, the Rockingham glove. That's what we'll be discussing this morning. Let's start with the sock. We know that on June 13th, when Mr. Fung went to collect the sock, not yet, he saw it on the throw rug, not yet, and he did not see blood. He did not see soil on the carpet. He did not see any trace evidence around, not on the stairwell, not on the carpet leading into the bedroom, not anywhere. There's supposedly a stain, an ankle stain, on these socks. You saw it cut out, about 1.5 inches, huh? More DNA in that than anything in this case. Wouldn't that, if it were there, have left a transfer, some specks, something? If they're in a struggle? You have children. I have children. You ever see them go out to play in dirt, like that closed-in area at Bundy? Get into some kind of ruckus, socks come back, they're filthy. Would have to be here, if there's anything on them at all. Nothing. Nothing there. Now, Mr. Fung is looking for blood. These socks are the only clothing they take. It's logical as a criminalist, as he admitted on cross-examination, that he would be looking at the ankle area, the one they would look to first, because that would be the most likely exposed. Sees nothing. He's running around trying to do testing of anything that looks like blood. No test of the socks. Then, on June 22nd, Dr. Baden and Dr. Wolf are permitted to go to the crime lab. And Michelle Kessler shows them the socks. They see nothing. Then suddenly, on August 4th, Mr. Yamauchi can't remember. It was some kind of general inventory. Mr. Matheson might have asked him. He can't remember what the direction was. It wasn't specific to the socks. Somebody said, go look at this stuff. And then, for the first time, they find the stain on the ankle. Now, we have evidence of the wet transfer, going through surface 1, surface 2, through the little holes in the sock to surface 3. It's pretty simple. If there's a leg in those socks, you can't have the transfer. Is this coincidence? All these things with the sock? Or is it corroboration? I say it's corroboration that something is wrong. Something is terribly wrong with the most important pieces of evidence in this case. It is a cancer that is infecting the heart of this case. You cannot render a verdict beyond a reasonable doubt based on evidence like this. So if we apply 2.01, an essential fact, the socks, Ms. Clark said, an essential fact, whose interpretation is the most reasonable? And even if you give some of those cockamamie explanations some credence, and you say, well, maybe, ours is certainly reasonable enough for you to, you must adopt it. And if you must adopt it, really, where does that leave us? If they manufactured evidence on the sock, how can you trust anything else? How, in this country, in this democracy, can they come in? There's no doubt Furman's a liar and a genocidal racist. There's no doubt about that. But there's really no doubt either that they played with this sock, is there? And if that can happen, that's a reasonable doubt for this case, period. End of sentence. End of case. It really is true. Not in this country. It's a test of citizenship, not in this country. Now let's go to the back gate. Can we have the next slide? Because you know there's more. There's more of this cancer. We don't have the rest of that? Put it all up. 117, put it all up, Howard. 117 was the stain taken from the back gates. And you know, there was something very strange about it, wasn't there? The blood drops at Bundy were degraded and had extremely low DNA concentrations. 117 had enough for an RFLP test. It was 27 times as much as 47, the first blood drop, 45 times as much as 48, 270 times as much as 49, 51 times as much as 50, 11 times as much as 52. This slide, like most of them I'm going to show you, is in evidence. And you know who brought us that testimony? Gary Sims from the Department of Justice. We have the next slide. That's 117, the one on the gate. Do them all. This is 115 and 116, the one on the lower parts of the gate. 15 times as much as 47, 22 times as much as 48, 135 times as much as 49, 25 times as much as 50, 6 times as much as 52. This supposedly has been out there from June 12th to July 3rd. And until that, there's no question. Sunlight degrades DNA. Moisture and bacteria degrade DNA. Why are these concentrations so much higher? And another point. There's DNA concentrations, but there's also a separate test, as you've learned, when you look at those yield gels for degradation. These samples are not degraded. How can that be? Nothing. Now, there's something interesting here too. The prosecution is now saying, well, it's on a different surface than the Bundy blood drops. Bundy blood drops are on cement. This is on a metal gate. Painted metal gate. So something magical about this that will prevent it from degrading at all in over 3 weeks. Remember, the blood drop number 50 is just a few feet from this bottom portion of the gate that's very, very close to the surface and all the same environmental insults. But you know what proves this argument totally fallacious? And I asked this question of Gary Sims, and you can go back. Remember the blood from the handrail? That was one of the last questions I asked him. It's very curious to me that they've never typed that. They're still testing. Remember the blood on the handrail as you're leading up Bundy. Same kind of surface. Totally degraded. Remember the samples from the front gate? There was blood on the front gate. Gary Sims's testimony, no question about that, severely degraded, just like the other samples from Bundy. So those are the same kinds of surfaces. So this explanation, don't pass the laugh test. Well, what's the other explanation that Ms. Clark offered you? Now this is a whopper. She said, well, it's the plastic bags. I mean, that's rich. They spent weeks trying to deny that putting samples in plastic bags doesn't degrade the DNA. Well, it does. I mean, you know that from the moisture. So now they're saying on July 3rd, when Fung made this collection, he put these swatches in a plastic bag, but he didn't let them cook as long in a truck as he did on June 12th. It's our own incompetence. That's the explanation. That accounts for these differences. Well, you know, that doesn't work either for a number of reasons. Number one, they were going, as you recall, on a tour of the crime scene. And Fung, apparently right away, all of a sudden, they found this stuff on the back gate. And there's no testimony, zero, as to how long it took Dennis Fung to bring those back to the evidence processing room, or how long he had them in a plastic bag, or what other things they had him doing. There's no testimony that he immediately went back to the lab, he didn't continue with them in the tour, or anything like that. And you know why it's significant that they can't come in here and argue that when they don't present evidence? Because they could have. Because we know that there are records of when you go back into that evidence processing room and get in the door. They could have demonstrated, if they really want to put this argument before you, they could have demonstrated how long it took. Or they could have brought him back here to testify about it. But frankly, if they brought him back here to testify about that explanation so late in the game, you wouldn't have believed him, would you? Now I'd like to talk about missing blood. And I think that we can talk about this in the following way. Access, opportunity, and the smoking gun, Nurse Thano Paratus. Could we have the first picture? Now, Detective Van Adder, the man who carried the blood, picked up blood from the coroner's office of Nicole Brown Simpson and Ronald Goldman, blood tubes that contained EDTA. Let's show them all. Remember these? These are pictures of both sides of the tubes. Just pull them out. I think the point is made. One after another. Covered with blood. He got those from the lab. He carried those. Those tubes, the testimony is, have EDTA in them. He carried them on June 15th. Now, we do not have records. There are no records of the amounts that were initially put in those tubes, or where he went, how long he went. No real evidence that we can examine about that, but he carried it. On the other hand, when we turn now to Mr. Simpson, that's enough. Yeah, he testified. He took him from the coroner's office and he brought him to LAPD. But there is no record of how much was initially put in those tubes, so we can't retrace the amounts. Now let's look at the handling of the defendants, Mr. O.J. Simpson's reference file. Detective Van Adder, as Mr. Cochran pointed out, was so upset about how this goes that when he was asked, well, when did you get the blood vial, he said 3:30. Well, it was 2:30, we know that. His testimony is he gets the vial of blood and he goes off and he has a cup of coffee and he's walking around Parker Center with a blood vial in an unsealed tube. And as you know, the rules are you're supposed to book it immediately. You can book it in that building, Parker Center. You can walk a mile, go a mile away, it takes just a few minutes, and you book them at Piper Tech, where the SID lab is, and you buy a DR number, which is the number for the case, and the case starts. That's what the rules say. But that's not what they were doing. Now, if it's 5.5, and we started with 8 cc's, and Yamauchi took 1, there's 1.5 missing. No way out of that. No way out of that. Now, Mr. Matheson came in, and you saw these incredible experiments that he was performing, where he went and he started taking, he looked at all the other times people went into the tubes, and he's saying, well, you know, if you pipette it out and you pipette it out, you may lose something over time. But let's face it, the Matheson explanations can't get around the 1.5 missing right away. There's 1.5 missing right away, and toxicology proves it, and they knew it. And what I'll leave you with this morning are 2 clips from Thano Paratus.
How much blood did you withdraw from Mr. Simpson?
Approximately 8 cc's.
But you say approximately, you did not measure the amount?
Well, it could have been 7.9 or it could have been 8.1. And I just looked at the syringe and looked at about 8 cc's. I went through the needle from his arm. I looked at it, I should say, it looked like it was enough, which it was enough. The 8 cc's, I was wrong in that 8 cc's altogether.
Good afternoon, ladies and gentlemen of the jury. When we left, I showed you 2 clips from Thano Paratus. In the first clip, he was under oath. He said, when he drew Mr. Simpson's blood, he looked at the syringe. And that's how he knew it was between 7.9 and 8.1. No doubt about it. Something he does all the time, routine, something people in this field would do and know. He looked at the syringe. Then, because they couldn't live with it, because 1.5 is missing, and they could have called Thano Paratus in a direct case and put him under oath, Mr. Goldberg goes out and does this statement, this strange, bizarre statement in Mr. Paratus' home, which they tell you is unscripted, or that is to say, I mean, let's not say he gave him a script, but I mean, common sense tells you that they spoke to this man before they went and did this videotape, and you could tell at parts he literally said, I don't remember, because he was forgetting certain parts of what he, I guess, what it was planned to say. But let's get down to the substance. I mean, this is not under oath. It is the only testimony you've gotten in this case that is not under oath, which is fairly extraordinary. But you know what's even weirder? It's what he said. His position is this now. First of all, you can see the syringe, and you can see the calibrations on the syringe. So now he's saying, well, the syringe was turned over, and I didn't see the numbers. Well, that's pretty strange. But I think that what's even more odd is that it is his position that he now realized that he goofed. How does he know? He says that he took one of these tubes, now these, are items in evidence, and he looked at it. And he now remembers, months later, that when he drew Mr. Simpson's blood on June 13th, he can remember the level that the blood was in the vial. And based on his recollection of where the blood is in the vial, he then starts putting water in to another test tube to get it up to that level. And then he says, well, that's 6.5. Well, that's not worthy of belief, is it? That you can remember all these months later the exact level, and that's how you come up with 6.5? So not only is it not under oath, and not only is it obviously a convenient recantation, and appears to have been prepared, shall we say, to suit the prosecution's purposes when things just didn't fit. But the story is an absurdity. It is just an absurdity. It is not worthy of belief. It is a reasonable doubt in and of itself. Blood is missing. Now I'd like to move to the blood drops found at Bundy. And there are two aspects of examining this evidence. The first has to go to the integrity of the samples, and the second one goes to the issue of cross-contamination. First, I would like to address the issue of the integrity of the samples. We start with the handling of the swatches. And we know that they are not counted at the scene. They are not counted when they get back to the lab and put into test tubes for drying. They are not counted the next morning when they're taken out of those tubes. There's no count. First time there's a count is when Yamauchi gets it between 9 and 11:20 that morning, June 14th. So we don't know how many swatches we started with originally. And as Dr. Lee told you, as all criminalists told you, as Gary Sims told you, it is the first duty of a forensic scientist to document the evidence and to establish a chain of custody that preserves the integrity of the evidence so that you can bring it into court and good people like you can feel satisfied that you have honest, reliable evidence. That was not done. No booking until June 16th. It's in the lowest security area, that evidence processing room where that metal gate can be lifted, where yes, you have to have a card to get into the door, but other people walk in and out and the entries are not monitored. It is an unlocked cabinet, and in this phase there is no way to trace the individual items. Now, we had asked, Your Honor, for the bindles to be produced, but they have not been produced. But you can get them. You can get them when you go back into the jury room. And there is one absolutely extraordinary fact in this case. On August 23rd, Andrea Mazzola was called to testify at a hearing in this court, put her hand on the Bible, swore to tell the truth. When she came in, she had her notes, the same crime scene log notes that she and Mr. Fung had reviewed in their testimony. She got on the stand and she was asked questions by Mr. Neufeld about how they went about collecting the swatches and the evidence in this case. And she described the process of taking up the swatches, coming back to the lab, putting them in the tubes for drying, taking them out the next morning, putting them into bindles, and then she testified that they initialed the bindles, that she, Andrea Mazzola, took some of them, Mr. Fung took others of them, and she initialed the bindles, those little white bindles that the swatches were in. You all recall that. She said that under oath on August 23rd. And you know, think about whether or not she would have good reason to remember and have a best recollection of what actually occurred when she testified on August 23rd. This case was the first crime scene that Andrea Mazzola had ever primary responsibility for collecting blood evidence. A good reason to remember. Between June 13th and August 23rd, when she testified under oath, Andrea Mazzola had not done another crime scene. So there was nothing to confuse her. Collected blood from a crime scene. When she testified, she knew that this was an important matter. I realized that she did not know who Mr. O.J. Simpson was. Fair enough. But she certainly knew that this was an important matter and that everybody was concerned about it, and you would expect that she would want to testify in a fashion to the best of her recollection, looking at those notes. She said, no question about it, that she initialed the bindles. You will get the bindles. We laid them out for you. You can look at 52, 50, 49, 48, 47. Her initials are on no bindles. Zero. Something is wrong. Could we have the board? Dr. Henry Lee is quite a remarkable man. And we tracked this evidence. His offer was not taken up, he and Dr. Batten, to examine this evidence. At the time it was collected, as the testing was going on, he did not really get a chance to examine and handle the evidence until February 16th, while you're still sitting here. However, we did try to track it as much as possible. and we were allowed to take pictures at the Cellmark laboratory of the swatches, and we were allowed to take pictures of the bindles and measure them and weigh them because something was wrong. And then we found the wet transfers. This is very disturbing, as Dr. Lee indicates, because the uncontradicted testimony is that these swatches were put in test tubes to dry for 14 hours. And Dr. Lee gave you his best estimate that he thought they would dry within 3. And then Mr. Goldberg came in with, you have that study? The Epstein-Barr study, and if we go to cotton cloth, indicates that it should take about 55 minutes, if you look at it, under condition number 1, that's at room temperature, to dry. That's enough. They should have been dry. I expect they'll come in and they'll say, well, there was a swatch sandwich, they were all stuck together so they wouldn't dry. Nonsense. Use your common sense. How do you get wet transfers like this? Well, within 3 hours of the time that they were taken out and put in bindles, if somebody had switched swatches, you'd see wet transfer. What happened in the evidence processing room that morning? We know that Mr. Yamauchi says he got the sample at about 9 from Mr. Fung. And on cross-examination, he said something that was really remarkable. Do you recall this? All of a sudden, he said, I remember now. I opened up the tube, and the blood spurted up through the creme wipe. And it got on my gloves. Now, he was a little vague about what he did with the gloves. He doesn't remember whether he put them in a biohazard bag right in the evidence processing room or got out and went to the serology lab and got rid of them there. But all of a sudden, we now know there was a spillage of blood there. Now, that is extraordinarily significant because there's plenty of high molecular weight DNA in the smallest drop if you get it on your gloves or if you don't change the gloves. And frankly, I think there's no reason to believe he did. To contaminate these samples that we know are degraded. And it's so easy to do that and not be aware of it. And it's so easy to do that when you're in a hurry. And it's so easy to do that when you're only out of training for 6 months and you're in a tough position. And it's so easy to do that and not really be aware of it. So easy to make that kind of mistake when you really haven't had the training. So easy to do it when you're handling 21 samples that morning in one day, something that an experienced technician like Gary Sims tells you it takes days to do. So easy to make that mistake and cross-contaminate these samples. So easy. What's most important is that there's an unacceptable level of risk. You cannot accept this presumption that it all went right beyond a reasonable doubt. There's no way. Now, interestingly, when he says, even by his testimony, that he opened up the tube, the blood spurted out, let's give him changing the gloves, although there's no real reason to accept that, frankly. There's still, by his own admission, going to be blood on that table. Blood that you can swipe with your gloves or your hands, and it doesn't take much to do this transfer. He didn't wash down that table. There was no paper there that he changed. There's blood on the table. A fair inference. Now, the next thing that Ms. Clark said, and I don't know if she was listening to the evidence that carefully in this phase of the case, to be frank, is she said, well, if there were contamination, if there were DNA flying around from Mr. Simpson's sample, then we would have seen proof somewhere else that his blood had contaminated other samples. That's what we would have seen. Well, there was. On June 15th, if you recall, a second set of samples was handled by Mr. Yamauchi. He had the reference tube from Nicole Brown Simpson, the reference tube from Ronald Goldman, and he had item number 12, which were the 3 blood drops picked up at the foyer in Mr. Simpson's residence. Those were the last drops picked up that day. They were the ones that were last put in a plastic bag, and Gary Sims has told us those are the ones that had the highest DNA concentration of any of the samples. Item number 12. They are the one that got an RFLP result from Cellmark. So we know that item number 12 is high concentration DNA. We know that item number 12 was being handled by Mr. Yamauchi on June 15th with the reference samples of Goldman and Nicole, which are also high concentration samples. And Dr. Gertie showed you how at LAPD, and then on the polymarkers at Cellmark, and then at DOJ, we got typings that were consistent with cross-contamination from item number 12. And all the controls on those second days, those negative controls, are clean. Because, as I'll discuss in a second, we've already proven these things happen with negative controls being clean. You get this cross-contamination. So, this was proof that Mr. Simpson's DNA, by sloppy handling, was cross-contaminated and typed lab after lab. And you heard that on cross-examination, Mr. Clark didn't even confront Dr. Gerties with this board. And you know what? He's a fine lawyer, and he knows this subject matter well. He didn't cross him on it because they can't touch it. Now I'd like to turn briefly to the hair and fiber evidence. You heard from, Miss Clark can say it's his hair or it's this fiber. But as she had to say in her closing, that is not what the testimony was from the witness, because hair and fiber evidence, as Mr. Diedrich pointed out, and as we all know, and as Dr. Lee pointed out, is what they call weak association evidence. It ain't DNA. It is weak association. We're talking about broad similarities. You can't even say the word match when you're talking about this evidence. It is really evidence by way of exclusion. They can't come up with a number and say this hair is, the odds of this being someone else's hair is 1 in 20. Can't even say that. It's just a question of looking at as many similar hairs to see if you can get an exclusion from a particular race. So there's no database, there's no number, it's just similarities. It is weak association evidence. Nobody is telling you that this is definitely somebody's hair is some particular fiber. There is carryover between the clothing. Now, what does that mean? That means, frankly, that the bodies were dragged through the crime scene, and blood from Nicole Brown Simpson got on Mr. Goldman, and vice versa. And if that happens, that's how the fibers can get carried over too. And Ms. Clark went on, and I think she even put some, little pieces of the puzzle up there. She went on with this rank speculation, where she was saying, well, we know that it was one killer. And we know it was one killer because we saw some fibers that came from Nicole's dress and got on Ron's shirt or jeans and then back and forth. And that's how we know that one person was going back and forth between two victims. Nonsense. This proves it. This proves that the hair and fiber and the blood evidence were all coming together because the handling of this crime scene is a disgrace. A disgrace. They're dragging the bodies back and forth. Okay. Now, also, it should be noted that it came out during the testimony of Ms. Brockbank that the 2 gloves and the 2 hats, the knit hat and the plaid hat found in Mr. Simpson's Bronco, and the Bronco carpet that was cut out of the car, were all placed in the same box. I mean, the way they handle this stuff, and then they want to come in and say there's integrity to the hair and fiber evidence, is ridiculous. Briefly on the hat, we had testimony about dandruff. You heard Mr. Simpson's barber say that in the off-season, in the summer, in spring, he gets dandruff. Right after he's arrested, they remove known hair samples. his hair has dandruff. There's no dandruff in the hair in that hat. Now, if we look at the hair and fiber evidence as a whole, there are, and this is just weak association evidence, nonetheless there are powerful inferences consistent with innocence. And these were put on slides that are in evidence. I'd like to review them briefly with you. Both gloves. No hair consistent with Mr. Simpson on the Bundy glove. No hair consistent with Mr. Simpson on the Rockingham glove. That's the slide we put up. But you know what we should have added to that slide? Very significant facts that I hope you don't forget. There was an unidentified Caucasian hair on the Rockingham glove. Did they test Mark Furman? Did we get a hair exemplar from him? Also, and this is a fascinating point, Cato the dog. His hair was found on the Rockingham glove. And I'd like you to read this testimony to you because I don't think it was an answer that Miss Clark particularly liked. And this was in the cross-examination of Mr. Diedrich. Question. And they were talking about Cato's hair, on page 34949 of the transcript. Is the finding of such hairs, Cato hairs, on the Rockingham glove accounted for by possible contact between the wearer of that glove, the murderer, and Cato the dog, either during or immediately after the murders? Answer, could have. It could have been a direct transfer for the dog, or as I stated before, an indirect transfer from hairs at the crime scene. Question, that were, say, where? Answer, on the ground maybe. Would have to have been on the ground. Question, have to have been on the ground? Answer, or perhaps from one of the victims who had been on the ground and collected the hairs. Question, and that you have previously described those as being common to the under part of the dog as opposed to the tuft or the coat. Now he's talking about the hair. This was a soft hair from Cato the dog found on the Rockingham glove. He's saying this is hair from the soft underbelly of Cato of the dog. The kind that you would expect to be shed if he were lying on the ground there. Not the kind that you get if the dog sort of pats you, all right, or it comes up on you as they're going to probably claim, fleeing the crime scene or something. It's a soft hair. It's the kind that you would find on the ground in the closed-in area. What does that mean? That means that Rockingham glove started at Bundy. Somebody took it somewhere else, and you know who that was. But now we have the problem for the prosecution that when they do the fingernail scrapings, they come up on the EAP system with a B. That is not O.J. Simpson's type. That is not Nicole Brown Simpson's type. That is not Mr. Goldman's type. It is some other person. And that's what their typing results showed. And so then, it doesn't fit. It can't be right. So we have to see if we can make an assessment that would somehow undercut that finding. Now remember, when you have two conflicting reasonable interpretations of evidence, in a circumstantial evidence case, you have to go with the inference that's consistent with innocence. Now let's look at what happened. Mr. Matheson said, I think what could be here is that we had, can we show this slide? A four-banded BA from the Nicole Brown Simpson that degrades into a two-banded B. Now you recall this testimony, I'm sure, and the cross-examination by Mr. Blazier, and the testimony by Mr. Sims, who'd been doing serology a lot longer than Mr. Matheson, had a lot of experience in conventional serology. These are the facts. The facts are, in the literature, this supposed degradation pattern that Greg Matheson suggests could occur does not exist. There is no literature. Dr. George Sensabaugh, all the experts in this field, that doesn't happen. Nobody has seen it. Mr. Sims, who did more conventional serology than Mr. Matheson, said he, in his experience, has never seen a four-banded BA degrade into a two-banded B. Never. Mr. Matheson says he thinks he recalls somewhere he saw it. That ain't good enough. That kind of maybe I saw it, that ain't good enough. Maybe doesn't cut it in a criminal case. We're talking proof beyond a reasonable doubt. This is nonsense. Ms. Clark was trying to say, well, this is how the blood got there. We know the Rockingham glove had a lot of blood, mostly from Mr. Goldman, some from Nicole Brown Simpson, and that was somehow placed on the side of the console. So that's why we get the little amount of Goldman's DNA that's on the console. That's their theory. Well, that's consistent with Mr. Furman placing the glove in there. It's consistent with even Mr. Furman having handled the glove and getting blood on his sleeve and just searching around the area, or one of the other police officers, and just getting a small smear of it with his sleeve on the console. That's consistent with this evidence. And you know what isn't consistent with this evidence? Think about it. What are they really saying? If Mr. Simpson had committed these murders and he grabbed the glove, as they're saying, with his open left hand, all right, and placed it on the side, well then in getting into the car, why aren't there mixtures on the window, right? On the window, on all those other drops, everything else, all those other blood stains. There's no trace of blood from either of the victims. There's no mixtures. Wouldn't there be other blood on the hands? And of course, their theory before you, this is extraordinary, is that he's wearing these clothes that we've just been through the evidence of struggle. If there's blood on pants, it's going to be on the seat. If there's blood from the struggle with Goldman, it should be there. We know there's no hair, there's no trace, there's no fibers from clothing, there's no berries. There's nothing in that Bronco that would be consistent with somebody that had committed a violent double homicide, that had been in a life and death struggle with Mr. Goldman. It doesn't make one bit of sense. If you look at the bloodstain pattern in the Bronco, you have to have a reasonable doubt about that. And haven't we shown you by credible, fair, and reasonable evidence that this Detective Furman would have gone in that car and by his own testimony and exposed lies from the prosecution's own witnesses, there's evidence he was there. Those stains on the door sill give up the lie, don't they? He was in that car, and probably more than one of them was in that car. Ladies and gentlemen of the jury, I thank you very much for your patience. I've tried to reason through this evidence, drawing the fair inferences as best we could, looking at the integrity of the evidence, and I just think there's very little question here, is there? So much of the essential facts in this case are just shot through with reasonable doubt. There is something wrong. There's something terribly wrong about this evidence. Somebody manufactured evidence in this case. There's missing blood. There's EDTA. There's questions, serious, deeply troubling questions. You must distrust it. You have to distrust it. You cannot render a verdict in this case of beyond a reasonable doubt on this kind of evidence. Because if you do, no one's safe. No one. The Constitution means nothing. This cannot, will not, shall not happen in this country with you good people. It just won't. Thank you very much.
Thank you, Mr. Scheck. You want to take a change over here?
Just 3 minutes or so.
All right. Ladies and gentlemen, let me ask you to just step back into the jury room. Probably be about 5 minutes.
Good afternoon again, ladies and gentlemen. Seems like we did this yesterday, but I won't be nearly as long this time. I'm back, as I promised you I'd come back, to try and wrap up the defense discussion of the evidence with you. You just heard what I believe was a remarkable discussion by Mr. Barry Scheck, an excellent lawyer. He may be from Brooklyn, but he's become a Californian as far as we're concerned. He is a very valued member of our team of defense lawyers for Mr. O.J. Simpson. And you see why. This is indeed a talented lawyer. And so he shared with you a number of things which I will not be redundant about and go over. You have them clear in mind. And if I were not to say anything else, there are many reasonable doubts in this case, and O.J. Simpson is entitled to an acquittal based on what we have told you. This is my last chance, of course, to speak to you, and I want to take this time to tell you again that the prosecution, because they bear the burden of proving this case beyond a reasonable doubt, will have the opportunity to speak to you last. We may not be here too late tonight because I'm not going to be much longer, and I think that more than likely, I think we can probably guarantee this case is going to get to you sometime tomorrow afternoon, so you can kind of sit back and relax. It's been a long, long, long road to get to this point. It's been kind of like a relay race, hasn't it been, in many respects, in this journey toward justice. The prosecution was first running with it. We then took the baton and we started running with it. We've run almost up to the jury box. And soon, we're going to pass the baton to you. This is how our system works. This is what makes it so great. We pass the baton to you, and we'll be glad we can then sit back and watch you at work. You watched us for a year, 2 or 3 days. Now we get to watch you. It'll be symbolically watching you because we won't see you back in that room, but you know we're going to be counting on you, giving both sides the benefit of your individual opinion. Now it's your time to perform. You know how you could think about us in those days when you wanted to criticize us? We're not going to criticize you, though. We're going to just watch you work. And watching you work is what makes this country so great. Because it's 12 citizens, good and true, coming together from this community from disparate backgrounds. Experience not required. Citizenship, the only requirement. To do justice, to do right, to right some wrongs, to straighten this out. That's what we're asking you to do. To follow the law, determine the facts, and come to a well-reasoned decision. That's what's going to happen tomorrow afternoon for you. Now, it may take 1 day or 100 days, but you've been committed. I know that you'll stay the course, keep your eye on the prize, and do the right thing. Now, when I sit down this time, I won't get another chance to argue to you or discuss the inferences because it has to stop sometime. But Ms. Clark gets to talk to you later tonight or tomorrow. And I want you again to use your common sense. And remember, if she raises some point, I may not be able to get up and respond, Mr. Scheck or I. If it's something that's not purely rebuttal, you may see more objections this time because we got to keep it in line. But if it's a point that we can't respond to, you substitute your wisdom and common sense as to any point. I think you know by this time we can answer anything that they would say. So I'm sure you'll give her the same attention you've given us today, and I wish them good luck. In fact, let me say this. In this case, we have been advocates. We have fought hard, I hope. But it's not personal. What is personal is this case. What is personal is our zeal and our desire that our client be acquitted. It's not personal against these prosecutors. In this part of our discussion, I want to share a couple of things with you and clear up a couple of things if I might. Remember, I was examining Detective Lang, and it was interesting that we saw Detective Lang here today. That's interesting, isn't it? Detective Lang was here. He's the only one who can really come anymore. We discussed the roles of these people It's the only one who's going to show his face here. You can count on. But Lang says that early on that they had, I asked him questions about traveling around the world to investigate this case, to get an idea of what resources were they putting on this case. You remember right at the very outset, the reason that robbery homicide was put on the case was because downtown they supposedly had better resources. There's some doubt about that, but they did that, and they put resources, including everybody in the LAPD. They had the DA's office and their investigators. They've had the FBI. They've been all over the world. You know, they've been everywhere looking for Bruno Magli's shoes. They've been to Italy. They've been to many of the states in the United States. And I asked them about those things to give you a scope of what they were trying to do. And, you know, it's awesome, the power of the state. And at one point I worked as the assistant district attorney, so I know about the power of the state. There's no priority to being on this side. I used to be on this side. You can be on both sides. You perhaps gives you a little different, a balanced perspective. But they have a lot of power. They can do a lot of things. They have a lot of resources. And they've used them in this case. So don't feel sorry for them. They've used every resource they had. When they didn't call people, there was a reason for it. It wasn't they didn't have the resources. These are excellent lawyers. They know the facts. If they didn't disprove something, if they couldn't disprove Henry Lee, if they didn't call anybody for John Gerdes, it's because they couldn't find anybody. Earlier, I talked to you about Detective Furman on this particular point. I wanted to make sure so we could be as accurate as possible. This question was asked by Bailey. There is a problem that has been brought to your attention, isn't there, Detective Furman? Answer, no. Question, when discussing this event in the preliminary hearing and talking about the glove, your tongue slipped and you said them, didn't you? Answer, yes. In case there was any question about what we'd said earlier. Mr. Scheck has covered the brush marks on the door, but what I'd like for you to do is look back at your notes, because Furman said that regarding these brush marks, he said he saw these marks on that door while the door of the Bronco was closed, remember? And the reason why this has become so important was he was trying to say he hadn't gotten inside. Then we called Larry Regal, who said you couldn't see the ones at the top unless the door was open. And then Furman also had said that he told Fung about these brush marks. If you look at Fung's testimony, I think you'll find that Fung never says that he heard that from Furman. And so, you know, with regard to Furman, I could have gone on and on and on about lies, but that would be counterproductive after a while, because you know who he is now. There's one other point I wanted to share with you about Furman before we take our leave of him, is that there was some questions in counsel at 18906 about opportunity for Detective Furman. And here was a series of quick questions. When you arrived at the scene this night, were you wearing a coat, a jacket of some sort? When I first arrived at the scene, yes. Can you describe it? Answer, a blue blazer. All right. And you were wearing the trousers and shirt that we see you in with your weapon in the picture pointing at the left-handed glove. Yes, tan slacks. Okay, now, at some point, did you walk back to your vehicle and take off your blazer and hang it to lay in the vehicle somewhere? Yes, sir. Okay. Can you tell the court and jury about what time of day that happened, bearing in mind that you arrived at about 2:10, that's a.m. It would be after I was relieved from the case. Now, he's relieved a short time after he gets there. He's relieved by 3 o'clock, isn't he? Before 3 o'clock. All right. That would be close to 3 o'clock? Yes, sir. Question. And that is when you walked back to the vehicle and left the jacket and stood waiting for your relief? Yes, sir. Now, I don't believe hardly anything he says, except that it is true that in this photograph taken at 4:30 or before sunrise, the one you saw, where he's pointing at the glove. He doesn't have a jacket on. So he had a jacket, went to that car by himself. There's many things in that car. This man had ample opportunity to get up to that scene. You know, as I told you, it so stretches the credulity to believe that so neatly placed were this knit hat and this glove. Were there two gloves at some point? When he says, I saw them, why would you say them? There weren't two gloves. And, you know, it's so unusual because everything else is spread all out. This was a vicious fight. There's a beeper over here and there's keys over there. But these items are right there, right where you can point at them. It's two pat. So you can ask yourself those questions when you go back into that jury room. Now, in this case, I discussed with you Miss Juanita Moore, a lady that I called to the stand, and I think I misspoke myself. I think I mentioned to you that, I think I may have said, she said that Mr. Simpson did not have dandruff, and if I did say that, I got that wrong. She said that Mr. Simpson would get dandruff, I think, in the off-season, in the spring and summer when he was here, as opposed to when he was in New York, and I wanted to make sure, in looking at the transcript over the lunch hour, I noted that. Ms. Clark seemed to be amazed when Mr. Scheck said that Kelly Muldorfer said that she didn't see blood in that Bronco, so to save her some time, I'm going to read you the transcript. Kelly Muldorfer at 38268, lines 26 through line 9, I think at 38269. Question, and when you looked at the console, do you remember seeing any blood there? Answer, no, I don't have any specific recollection. That's the lady, the investigator, who was looking at this. The defendant is not required to prove him or herself innocent or to prove that another person committed the crimes charged. So now, if that's what the law is, and the judge gave you that, or Mr. Darden asked the question, who did this? Who committed this crime? Why would he ask that when the judge just said, the defendant doesn't have to show anything? And we know in this case, they rushed to judgment, they didn't look at anybody else. That's a question he should be asking these detectives, not us. We're the ones who had the preeminent experts who wanted to help out. They wouldn't accept them. How could he ask us that question? How could he ask us that question in good faith? So what the answer is, you go ask your detectives. That's the answer. Now, he asked another question. He said, well, where was O.J. Simpson? And he says, well, you know, how does he account for his whereabouts after 10 o'clock? Well, let me just take a minute about this. He asked that question. So let me answer it for you and for him. Some of you in your former life probably lived alone. If you lived alone, if something happened between 10 o'clock and 6 o'clock in the morning, it's real difficult, if you live alone, to prove where you were if nobody lives there with you. Isn't that true? Is that common sense? Mr. Simpson lived alone. But we've done more than that. We can establish where he was. He was at home. That Bronco was outside. He was packing and getting ready and rushing around at the last minute and coming outside to that Bronco, getting his phone, getting the paraphernalia for that phone. That's what he was doing. He was packing. He was getting the golf balls, the golf bag out of his car that was seated out there. He was getting golf shoes and whatever goes with golf if you're a golfer. That's what he's doing. He's getting this little knapsack out that has golf balls in it. And he was bringing another bag down, all of which were ready when Park and Cato were out there. And he comes down with the other bag, carrying it. That's what he was doing, Mr. Darden. That's where he was. It's your speculation. He's on the side of his house running into an air conditioning. That didn't happen. That's unreasonable. Nobody here believes it. It's not going to help save their case. They're speculating again. Speculating. Cynically speculating. And it's not going to work. And so that brings me to this other instruction. It's called alibi. You remember during voir dire I asked you about this. I said that you won't place a bad connotation on the term alibi. That's what the law calls it, alibi. And it says as follows, that evidence has been received for the purpose of showing that the defendant was not present at the time and place of the commission of the alleged crime for which he is here on trial. If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. Can I repeat that last part for you? If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed. It doesn't say you might find him not guilty. You might think about it. It says you must find him not guilty. And so, you know, when you talk about this whole concept of reasonable doubt, and we'll talk a little more about that, it's how you feel inside about this evidence. It's how you feel inside about these messengers and their message. It's when you have that queasy feeling. You can't trust this evidence. Barry Scheck described it well as a cancer. He talked about one cockroach you don't need to see anymore, because you know if you see one, there's a lot of them around. All you need is one, and that's going to make you go the other way. In this case, you don't have to get past the socks. But then you get to the glove and the Bronco, and you get to all of it, none of which you can trust. And then how do you do it? Do you get back there and say, well, I don't trust him on this. I think I can trust him on that. When these essential link in the chain is broken, you got reasonable doubt. And so your job won't be quite as tough as you may have thought. Reasonable doubt? In this case, the prosecution has not offered one coherent theory to explain how these deaths occurred. He came home because his little girl was having a concert. That's the kind of dad he is, and somebody has to stand up for him. People don't want you to stand up for him. People can't stand the truth, but they're going to hear truth in here. There's one place you can't take away somebody's voice, and that's in the courtroom. When you want to tell the truth. For 16 months, this man sat over here and heard people talk about him day in and day out, judged him and prejudged him against the American way. What right? How dare them do that? And he has 1 day or 2 days to have somebody stand up for him, and people are crying and moaning. It's outrageous in America. It's intolerable, if you will. And so this is a good and decent man who loves his family, loves his kids. None of us are perfect. But he's a man who went a long, long way. Raised primarily by his mother, you know what he did with his life. He had a good life, a wonderful life. He's done well. He's not going to give all that up? Try and kill somebody with a knife? He's not going to give that up. And you know what? You should think about this case. Can you imagine that a man who loves his children so much is going to go over, kill his ex-wife, kill their mother, and leave her so that the children can come downstairs and find her? That defies credulity. None of you believe he would do that. It's contrary to everything that you can believe and that you've heard about this man and what he's done and what he's done with his life. So forgive me if I speak out for O.J. Simpson. If I'm so presumptuous as to believe that the Constitution means that you're presumed to be innocent until you make the decision. Nobody outside here has a vote. You have that vote, thank heaven. These narrow-minded people, thank heaven they don't have a vote. You will have the final say. The prosecution had a puzzle. And it was interesting how they did this puzzle. Technology is wonderful. And you saw they kept, under this puzzle, putting on pieces and that sort of thing. And so we thought about that. I thought about this puzzle. thought about what it meant in this particular case. I got a call from a very, very wise lady who reminded me that if you've ever gone to the store and bought a puzzle, when you buy a puzzle, on the outside of the box of the puzzle, there's a picture. So you know what the puzzle looks like when it's finished. Well, in this case, the prosecution took a photograph or picture of O.J. Simpson first. Then they took the pieces apart. If they really wanted to talk about reasonable doubt, you don't jump to conclusions at the beginning. You don't rush to judgment and then be concerned about an obsession to win. What you do is you take the pieces and put them together, and then you come to the conclusion. They got it all backwards. It's like what they did with the Fourth Amendment. It's like asking us, where is this witness? What did you prove? Solve this crime for us. They got it all backwards. Don't you see? And so that little example, a jigsaw puzzle, was clever, but really it trivializes a man's fight for his freedom, who's always said that he was innocent from day one. So I wanted to just summarize our sense with a graphic, thanks to Mr. Bob Blazer, of this evidence and why there's reasonable doubt as to each of these items. Please note the monitor. All right, let's look at first. We know in the upper left-hand corner there's missing blood. They can't explain it, and they went down in flames, going out with a home video where it was actually embarrassing this morning. You want a little levity during the tough times in your deliberations? Play the Thanoparatus video. In fact, it's so bizarre that if you listen to it again, you'll hear Hank Goldberg is laughing himself. He starts laughing when, if you look at the words are mouthed by Paratus, he goes like that, and Goldberg starts laughing at his next question. How embarrassing this is, but this blood is still missing. You'll have that syringe there. So Mr. Blazer and Mr. Harris, what does that mean, that missing blood? It means reasonable doubt. Then we have the socks, my personal favorites. And when I talked to you about the socks yesterday, I may not have told you that in addition to the socks not being in the video at 4:13 on June 13th, and how they placed them there later, and how they were collected at 4:35 or between 4:30 and 4:40, Willie Ford came in here and testified to you he didn't see the socks. Forgot to tell you that yesterday. He testified they weren't there either. So thank heaven there's one person who wasn't part of that cover-up, although they got to him and he was saying things, oh, well, the socks may have been covered. But he still works over there. So we'll forgive him for that, but he didn't know what we knew about Lang and Mazzola and the time they were collected in their log. Plus that, the timing on the whole thing got them. And those straps on the bed further. So what have we shown you about the socks? Reasonable doubt. That moves to the back gate. What about that back gate with the EDTA and more DNA than you could ever imagine, and it's picked up and collected 3 weeks afterwards when people have been all over the place, and you saw the photograph? Look at that photograph. That photograph doesn't show any blood, it shows some little tiny spot. It's totally inconsistent. They're trapped again by the video. This case will go down as the video case because we have shown you for your own eyes why they lose this case, why there is reasonable doubt. So the back gate, reasonable doubt. And then we started out with the timeline because we knew at the outset the timeline with the witnesses that they failed and refused to call establish a reasonable doubt. It shatters the prosecution case. If you start there, you'll find these witnesses credible. O.J. Simpson couldn't have committed these crimes. There's reasonable doubt. He's not guilty. The timeline. We went from there to the EAPB, and you'll remember that, and Mr. Scheck has talked about it. I won't be redundant. The double-banded B, that's somebody else. They can't explain it. They never tried to explain it, except to talk to you about something that's not in the literature. It didn't work. There's reasonable doubt about who that person was. O.J. Simpson's demeanor. All those witnesses who didn't know each other, who you heard, who they talked to, you saw them all. You think that he was acting for those people? And you remember that one of the most interesting things was Mr. Darden said that when the Scott Kennedy video at the
June 12th recital, where a man just happens to stop by and takes a video. Simpson doesn't even know he's being videoed. This guy doesn't know Simpson. He's taking a video. Just came to us out of the blue. They had the audacity to tell you he was on camera. You know anything about being on camera? Somebody's taking a video of you. How do you know that? But we had that video, and they have nothing else to say. You ever notice when they have nothing else to say, how they just say anything? That's an example of that. That's an example of O.J. Simpson's demeanor, and that was our answer to this so-called fuse. We had proof for you. You saw him on that date, and we took you through step by step through that date. We've already covered the EAPB, the Bundy blood drops that Mr. Scheck did such a great job on, and you know about those drops. You know the numbers as well as we do, and I won't go over those anymore. I think there's reasonable doubt based upon those, and of course you know the Bronco. How can you trust the Bronco? Chain of custody, how can you trust it? There's nothing you can trust about that Bronco and how they handle it. And then the gloves. The gloves didn't fit. The gloves didn't fit. The gloves didn't fit. Reasonable doubt. And then the why. Now, motive is not an element of the crime of murder, but absence of motive would tend to establish innocence. That's why Mr. Darden went to such a long and exhaustive study. And I've shared with you the fact that there is no motive in this case, but I just want to briefly tell you this about their theory at the end. If you believe what the prosecutors want you to believe, you have to believe that O.J. Simpson, who has a limo driver coming, I guess around 10:30, 10:40, after he goes and gets a hamburger at McDonald's, after having been worried about change because he had $100 bills, that he's already been packing because clothes are being brought down, and he's taking his golf clubs because he is going to play golf, and that makes sense as a pre-planned trip. He's just off the road and going back on the road. That he is perhaps the most recognizable person in Brentwood, in that area where he's lived, we know, for 17 years. That he drives a white Bronco. That he decides to put on a knit cap, and you saw that exhibition yesterday of him or you or I in a knit cap. He decides he'll put that on. He changes out of his tennis shoes, his Reebok tennis shoes, and his sweat socks, and puts on some dress socks, and puts on some Bruno Magli shoes. And let me just stop right there for a minute, put a pin in that. The Bruno Magli shoes, you heard all about Bruno Magli shoes and Bruno Magli shoes, and we searched all around the world, and we went to Bloomingdale's, and what did we find? There is nobody who ever sold O.J. Simpson any Bruno Magli shoes. They searched, they tried, they never sold him any shoes. So they just been talking about Bruno Magli shoes. I mean, there must be every other house in Brentwood. If somebody wanted to afford some Bruno Magli shoes, I guess they could. Now that's their case. There is no evidence that O.J. Simpson had any Bruno Magli shoes ever. In fact, when Lang is looking for the clothes and O.J. Simpson says, this is what I wore, here are the tennis shoes, he took only tennis shoes that night. There is no evidence that O.J. Simpson ever owned any Bruno Magli shoes, and please remember that. So he puts these Bruno Magli shoes on, and he's trying to disguise himself, of course. He puts on a pair of gloves that don't fit, and he gets in his car, and he decides that what he'll do is he'll drive over to the alleyway behind Bundy where his wife lives, in this big Bronco. Now, while he's going to do that, he's been over there a number of times, and you know they've already told you about Pablo Fenves and these people who live back there. You remember when you went on that jury view? There are homes and windows and things that face down on that alley, on both sides. From, I guess, Gretna Green side and from the Bundy side. People are looking down in that alley. It's well lit. You saw the photograph yesterday of what Mark Storfer would have seen. He pulls into this alleyway in this Bronco, in this disguise, dressed the way they want to have him dressed. So he's come and kill his wife. Now somehow, and trying to kill his wife or whatever, he doesn't kill her in the back there where the car is. He goes and lures her to the front gate. Doesn't make any sense, does it? He goes to the front gate to lure her to that front gate. And then he gets into a fight, somebody he doesn't even know. This fight goes on for 5 to 15 minutes. The fight is so fierce that a hat and a glove are torn off. That's how fierce this fight had to be. The keys, the beeper. You saw how tough it is for any kind of an altercation. For gloves to come off, for a hat to come off. There's kicking, there's all kind of fighting in this small area. But that's what they want you to believe. And so we find the keys and the beeper and the gloves, of course, we find specifically the cap and the gloves neatly packaged under the item there. And then he leaves this one glove behind and then just walks slowly out to the alleyway. Now, the dog that we heard so much about, who he bought, who was his dog, doesn't go with him. He goes the other way, out the front to go down the other way. Cato, the dog, under what they would have you believe. And he's got these bloody clothes on and everything. Now he goes back out there where his car has been sitting 10, 15, 20 minutes. Right out there in the alleyway. Anybody could look, anybody coming home, people are driving up and down the street. Gets back in his car. Then presumably he races back home where the limousine driver who's there doesn't hear him come up, doesn't see him, doesn't do any of those things. And we know from the time they see O.J. Simpson, within 5 minutes, he's coming downstairs, packed, luggage is already down there, looking neat as a pin, heading for the airport. Now, he was expecting this man after he came back from the hamburger. This is what their case is. This is what they want you to believe. And just for good measure, it's not enough. That's not enough. Under their scenario, once he gets home, after he's rushing, he's got enough time, he's got all these bloody clothes on, he runs down the side of his house, where he's lived for 17 years, and runs into the air conditioning. It says, oops. No marks, of course, on his body. But while he's back there, he drops a bloody glove to match the other glove found over at Bundy. And just for good measure, so they'll be sure and find it, he knocks on the wall. He doesn't run into the wall. He knocks on the wall. He says, he gives a signal. Then he decides he comes in the house, but nobody sees him do any of that. That's what they have you believe. That is the prosecution's case. We have been here 1 year, ladies and gentlemen, and 2 days to hear this is what they have told you. It just doesn't fit. If it doesn't fit, you must acquit. Something is wrong with the prosecution's case, and your common sense is never going to let you fall for it. So the other side, of course, we submitted in answering the questions that O.J. Simpson was at home getting ready for his trip. He had no problem with his ex-wife. He had gone to this concert. She had gotten the tickets for him. There's no argument. Nobody's come in here, so they had any argument that day. There's no fight. They talked earlier, made arrangements for the tickets. He went to the concert. You saw him at the concert. You traced his steps that day and what he did. And then he went on to Chicago and came back immediately. And everything he did was consistent with innocence. This case is a tragedy for everybody. For certainly the victims and their families. For the Simpsons family. They're victims too because they lost the ex-daughter-in-law. For the defendant. He's been in custody since June of 1994 for a crime that he didn't commit. Someone has taken these children's mother. I certainly hope that your decision doesn't take their father and that justice is finally achieved in this case. One final word about Alan Park. We talked a lot about Alan Park. He's somebody that Ms. Clark, of course, found credible. But even credible people don't get everything right. Remember the golf bag? He thought it was a blue golf bag, and we know it's black with the insignia on it.
We know that there was a lot of questions asked about whether you saw a car parked at the curb, and I read you the portion that when I questioned him where he said he hadn't really been looking. He was not very clear with regard to that. But like all witnesses, you hold them up to the same standard and look at them. And so now, I promise you we're going to coming to the end. If after hearing all of this evidence, you have a reasonable doubt, it is clear that O.J. Simpson is entitled to an acquittal. And whether it is O.J. or no J, the result would have to be the same. His status doesn't count. It's the evidence that counts and what's been proven to you under these circumstances. But he is a good and decent man who you have seen and observed every day. We're in session since September 26, 1994. Now, as it comes time for me to conclude my remarks, I may never have an opportunity again to speak to you, certainly not in this setting, maybe when the case is over. As you've been told many, many times, there's a very heavy burden placed upon the people, and for good reason. Prove this case beyond a reasonable doubt. As such, it is Ms. Clark's duty to answer for you, as best she can, any legitimate questions arising from the evidence, which we believe casts doubt upon Mr. Simpson's guilt. There may be 1,000 such questions in a case like this, which can be put to her, but we intend no such exercise. I do think, after careful deliberation, that it might be fair to suggest 15 questions, just 15 questions, which literally hang in the air in this courtroom at this moment, and as the time approaches for you to decide this case, for us to hand the baton to you. I offer these questions now as a most important challenge to the prosecution. The prosecution which claims that it's met its burden in this case. If that burden has in fact been met, you will be given logical, sensible, credible, satisfying answers to each of these 15 questions. If the questions are overwhelming and unanswerable, they will be ignored, or you'll be told that the prosecution has no obligation to answer the questions. If you're given anything less than a complete, sensible, and satisfactory response, satisfying you beyond a reasonable doubt to these 15 questions, you will quickly realize that the case really is transparent, and you'll think about the scenario that I just went through for you, and that the term smoke and mirrors that you heard about doesn't apply to the defense. We proved real hard things for you, things that you can see, things you can take back in that jury room. And accordingly, you'd have to find Mr. Simpson not guilty. When I've concluded, for Ms. Clark's convenience, should she decide to deal with these very troublesome questions, I'm going to leave a written list of these questions here when I conclude. Let me go over these 15 questions with you just briefly. 1. Why, they're on the monitor, did the blood show up on the sock almost 2 months after a careful search for evidence? And why, as demonstrated by Dr. Lee and Professor McDonald, was the blood applied when there was no foot in it? Think that's a fair question? In this case, let's see if she can answer that question. Question number 2. Why was Mark Furman, a detective who'd been pushed off the case, the person who went by himself to the Bronco over the fence to interrogate Cato, to discover the glove in the thump, thump, thump area? Number 3. Why was the glove still moist when Furman found it? If Mr. Simpson had dropped it 7 hours earlier, as Agent Bodziak told you, Sir McDonald has told you, blood dries very rapidly. 4. If Mark Furman would speak so openly about his intense genocidal racism to a relative stranger,
such as Kathleen Bell? How many of his co-workers, the other detectives in this case, were also aware that he lied when he denied using the N-word, yet failed to come forward? Part of Barry Scheck's fourth C of continuing cover-up. 5, why did the prosecution not call a single police officer to rebut police photographer Rokar's testimony that Detective Furman was pointing at the glove before Furman went to Rockingham? That is around 4:30 in the morning. 6, if the glove had been dropped on the walkway at Rockingham 10 minutes after the murder, why is there no blood or fiber on that south walkway or on the leaves the glove was resting on? Why is there no blood on the 150 feet of narrow walkway or on the stucco wall abutting it? And you've been back there. Number 7, for what purpose was Van Adder carrying Mr. Simpson's blood in his pocket for 3 hours and a distance of 25 miles instead of booking it down the hall at Parker Center? Number 8, why did Deputy District Attorney Hank Goldberg, in a desperate effort to cover up for the missing 1.5 milliliters of Mr. Simpson's blood, secretly go out to the home of police nurse Thanoparatus without notice to the defense and get him to contradict his previous sworn testimony at both the grand jury and the preliminary hearing? Paratus was never sworn. We were never given notice. 9, why, if according to Ms. Clark, he walked into his own house wearing the murder clothes and shoes, is there not any soil or so much as a smear or drop of blood associated with the victims on the floor, the white carpeting, the doorknobs, the light switches, and his bedding? 10, if Mr. Simpson had just killed Mr. Goldman in a bloody battle involving more than 24 knife wounds where Mr. Goldman remained standing and struggling for several minutes, how come there is less than 7/10 of 1 drop of blood consistent with Mr. Goldman found in the Bronco? Number 11, why, following a bitter struggle allegedly with Mr. Goldman, were there no bruises or marks on O.J. Simpson's body? And you'll have those photographs back in the jury room. Number 12, why do blood stains with the most DNA not show up until weeks after the murders? Those on the socks, those on the back gate, those are the 2 major areas. Number 13, why did Mark Furman lie to us? Why did Phil Van Adder lie to us? And finally, 15, given Professor McDonald's testimony that the gloves would not have shrunk no matter how much blood was smeared on them, and given that they never shrank from June 21st, 1994 until now, despite having been repeatedly frozen and thawed, how come the gloves just don't fit? I'm going to leave those questions for Ms. Clark, and we'll see what she chooses to do with and about them. That'll be her choice. But I think you have a right to demand answers. If you're going to do your job in this case, it seems to me you will need to have answers to those questions. Now, there are many, many, many more, but as with everything in this case, there comes a time when you can only do so much. We took 15 as representatives, but I can tell you we had more than 50 questions. But 15 will be enough, don't you think? I think so. In this case, when we started out a long time ago, we talked a lot about truth. And I always like, in a circular fashion, that you kind of end up where you started out. Truth is a wonderful commodity in the society. Some people can't stand the truth. But you know what? That notwithstanding, we still have to deal with truth in the society.
Carlyle said that no lie can live forever. We've seen a number of big lies in this case, in this so-called rush to judgment. We've seen lie after lie, so much so that at least two of the major witnesses, Van Adder and Lang, Van Adder and Strike That and Furman, their testimony by you may be totally disregarded, further dismantling the people's case. You have that right, you know, in this search for truth. In times like these, we often turn to the Bible for some answers to try to figure out, when you've got situations like this and you want to get an answer and you want to try to understand. I happen to really like the book of Proverbs, and in Proverbs it talks a lot about false witnesses. It says that a false witness shall not be unpunished, and he that speaketh lies shall not escape. That meant a lot to me in this case, because there was Mark Furman, acting like a choir boy, making you believe he was the best witness that walked in here, generally applauded for his wonderful performance. Turns out he was the biggest liar in this courtroom during this process. But the Bible had already told us the answer, that a false witness shall not be unpunished, and he that speaketh lies shall not escape. In that same book, it tells us that a faithful witness will not lie, but a false witness will utter lies. Finally, in Proverbs, it says that he that speaketh truth showeth the forthrightfulness, but a false witness shows deceit. So when we're talking about truth, we're talking about truth and lies and conspiracies and cover-ups. I always think about one of my favorite poems, which I think is so very appropriate for this case. You know, when things are at the darkest, there's always light the next day. In your life, in all of our lives, you have the capacity to transform some of Mr. O.J. Simpson's dark yesterdays into brighter tomorrows. You have that capacity. You have that power in your hands. And James Russell Lowell said it best about wrong and evil. He said that truth forever on the scaffold, wrong forever on the throne, yet that scaffold sways the future, and beyond the dim unknown standeth God within the shadows, keeping watch above his own. You walk with that every day, you carry that with you, and things will come to you, and you will be able to reveal people who come to you in uniforms and high positions who lie and are corrupt. That's what happened in this case. And so the truth is now out. It's now up to you. We're going to pass this baton to you soon. You will do the right thing. You've made a commitment for justice. You'll do the right thing. I will someday go on to other cases, no doubt, as will Ms. Clark and Mr. Dart. Judge Ito will try another case someday, I hope. But this is O.J. Simpson's one day in court. By your decision, you control his very life in your hands. Treat it carefully, treat it fairly. Be fair. Don't be part of this continuing cover-up. Do the right thing, remembering that if it doesn't fit, you must acquit. That if these messengers have lied to you, you can't trust their message. That this has been a search for truth. That no matter how bad it looks, if truth is out there on a scaffold and wrong is in here on the throne, remember that the scaffold always sways the future, and beyond the dim unknown standeth the same God for all people, keeping watch above his own. He watches all of us, and he'll watch you in your decision. Thank you for your attention. God bless you.
Thank you very much, Mr. Cochran. All right, let me see counsel up at the sidebar without the court board, please.
A powerful, passionate ending for Johnnie Cochran, quoting poetry, talking about truth on the scaffold, talking about what should happen in this courtroom, ending, invoking the name of God, telling the jurors, God bless you. We see O.J. Simpson, as we can look upon the screen, looking emotional, conversing with his counselor, Mr. Kardashian being one of his good friends, as well as a lawyer for him, and some smiles upon the faces of the defense lawyers.
All right, ladies and gentlemen, contrary to our previous schedule, I'm going to recess for the evening at this time. We will resume tomorrow morning at 9 o'clock, and the lawyers have promised me that we will finish this case. One of the conditions that we go over until tomorrow morning is that we will finish tomorrow afternoon with the rebuttal arguments by the prosecution. I will instruct you, and the case will be yours tomorrow afternoon. And I hopefully we'll at least get it far enough to have you go in, select a foreperson to preside over your deliberations, and then Mrs. Robertson has a list of the exhibits and everything that will be presented to you so you can get organized for the coming days. All right, having said that, please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. We'll see you tomorrow morning, 9 o'clock sharp. All right, we'll be in recess. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, Mr. Neufeld, Mr. Scheck, people represented by Ms. Clark. Jury is not present. Counsel, just one matter before we get started this morning. You should have on your desk there the court schedule upcoming. And if you recollect, the one thing that's missing on the court schedule is that we had agreed to be dark in this matter. My recollection was Wednesday the 4th and concluding early on Tuesday, and that will be in effect for that date as well. All right, anything else we need to take up? All right, Deputy Smith, let's have the jury, please.
Sorry, Chris.
Quiet, please.
Sorry, Chris.
All right, we're about to clear the courtroom.
Your Honor, Ms. Clark was just showing us some boards they have, some new boards we've not seen. When Your Honor came out, we just started looking at the first one. Maybe we have a few minutes to see the boards.
How many do you have, Ms. Clark?
No, there's not just boards in there. And if there are any graphics, we'd like also to see those.
All right, let's see the boards.
All right, and then we'll find out about graphics. Sure.
All right. All right, counsel, this is going to be a discussion on the record, not amongst ourselves here, all right? I've seen it. All right, let's see the peels. Very nice.
It was one of the things that my guest commentator and I last night, Lane Leroff, and I discussed about the timing of the rebuttal argument. I know if I were defending this case, I would have tried as hard as I could to push for the prosecutor to have to start yesterday and not give them the opportunity to prepare overnight. That's something in terms of timing that lawyers do like to think about.
Oh, yes, very much. It makes an enormous difference whether it's cross-examination or an argument or anything else that you have to respond to the other side. To have a little bit of extra time to think about it really does give the prosecution a boost here to have overnight, even though they're going to be tired and not have a lot of time to think it through.
In this particular case, much more than most, these prosecutors could have basically prepared their closing argument, both their opening argument and their rebuttal argument, ahead of time. Regardless of what imagery was used, what metaphors, similes, analogies, the Bible or history were used, the facts that the defense was going to talk about were pretty etched in stone by the time the evidence closed.
That's right, and trial lawyers generally try to have a final argument in mind when they begin a case, to try and have an idea of how the evidence is going to come out. And certainly there have been a lot of developments that have changed that over the course of the trial, but they've had both sides a lot of time to think about what they're going to say, and there are no great surprises here for either side either.
My point being that if you first start organizing your case by dealing with the law, then the second thing you would do is really write your closing argument or the structure of your closing argument, and from there working backwards to what your direct and cross-examination might be.
That's right. You build from the bottom line up, trying to indicate
Any other comments?
all the things you have to prove from the start.
That's it. That's it. All right, Deputy Smith, let's have the jurors, please. I'm sorry, let's clear this, and then we'll have the jurors. All right, at this time, the defense has concluded their summation, and the prosecution now has the opportunity to offer their rebuttal to the defense summation. And Ms. Clark, the prosecution may proceed. All right, thank you very much. Mr. Darden?
Thank you.
Good morning, sir.
Good morning. Well, we've come full circle again, it seems. Here you are, and here I am. And as Judge Ito just indicated, this is my last opportunity to speak with you. That is until after you render your verdict. If at that time you're kind enough to spare a few moments and allow me to thank you personally at that time, not only for your verdict, but for your service as well. You've got a tough job. Very tough job. I don't envy you in that regard. But let me tell you something. I've had a tough job too. The law is a tough thing to enforce in this town. Not everybody. Not everybody wants to live up to the law or follow the law. Not everybody thinks that the law applies to them. I've been a prosecutor for almost 15 years. And if there's one rule that I've lived by, if there's one rule that means a lot to me, it's this one. No one's above the law. Not the police, not the rich. No one. And I hope you agree with that. I hope you agree with that rule. I hope you consider that that motto. O.J. Simpson isn't above the law. You've heard a lot of argument over the past couple of days, and I know you listened to all of the attorneys in this case intently, and I did when I could. And I listened yesterday, and I had been anticipating yesterday's arguments from the defense. I knew that those arguments would be passionate. I knew they'd be loud, and I knew they'd be forceful, and I knew that they'd be provocative. And I wasn't disappointed. But I also knew that they wouldn't talk much about the evidence. Well, Mr. Scheck did. But that's okay. And I knew they'd want to deliver a message to you, and that's why when I spoke to you the other day, I said to you, hey, you can't send a message to Furman. You can't send a message to the LAPD. You can't eradicate racism within the LAPD or within the LA community or within the nation as a whole by delivering a verdict of not guilty in a case like this where it is clear, and you know it's clear. You feel it. You know it. You know it in your heart. You know it. As you have sat here day after day listening to this testimony, you know it. Everybody knows it. Everybody knows he killed.
Overruled. Proceed.
Everybody knows.
Overruled. Proceed.
The evidence is there. You just have to find your way through the smoke. You just have to find your way to the smoke. You heard from Mr. Scheck yesterday. You heard him talk about our science. They have to attack our science because all the science points to O.J. Simpson, to this defendant. It all points to him as the killer. They have to attack that science. Not only does common sense dictate that he is guilty, we have proven him guilty to a scientific certainty. We've proven him guilty beyond a reasonable doubt. They hoisted that chart up on the thing there yesterday with reasonable doubt. You remember that chart? It had reasonable doubt at the top, and below that it had highly unlikely and all this other stuff. They put it on this thing, and then they hoisted it all the way up to the ceiling. That isn't reasonable doubt. That's not what I'm required to prove to you. Mr. Cochran said to you, well, reasonable doubt is doubt with a reason. That's not reasonable doubt. When you look back at that instruction, when you look back at the reasonable doubt instruction, you'll see when it comes to human affairs, there's always some degree of doubt, no matter how small. The sun could explode tomorrow. It could explode today, but I doubt that that'll happen. I really have no reason to believe that's true. I have no reason to believe that the sun will explode today or tomorrow. When you read the reasonable doubt instruction, read it and apply it to your everyday situation, your everyday circumstances. What does it take? What does it take you as a human being after hearing all the evidence and hearing the law that the judge gives you? What does it take for you to feel comfortable in your conclusion that he killed these people? They said that you have to be able to wake up the next day and feel as if the day before, the day that you rendered your verdict, that you did the right thing, that you rendered a verdict that you can live with. Let me ask you this. If you were to acquit him, what explanation would you give the day after that acquittal? If someone said, why did you acquit him? Would you say racism? Would you say it's because there's racism in the LAPD? That's what they want you to say. That's what they want you to think. You heard all of that, all the speaking and the fiery rhetoric and the quotes from Proverbs and the like. You heard all of that yesterday, all of that fiery rhetoric. Well, let me tell you what Marcia Clark and I are. Let me tell you who we are. We are the voices of calm and reason in all of this. You just need to calm down. Take that common sense God gave you. Go back in the jury room. Don't let these people get you all riled up and all fired up because Furman is a racist. Racism blinds you. Those epithets, they blind you. You never heard me use that epithet in this courtroom, did you? I'm not going to put on that kind of show for you know who, for people to watch. That's not where we're coming from. We want you to focus on the evidence. I am eternally grateful that Mr. Furman was exposed to be what he is. Because I think we should know who those people are. I've said it once, I've said it before. We ought to put a big stamp, tattoo it on their forehead, racist, so that when we see them, we know who they are, so that there's no speculation, so that we don't have to guess. But what they want you to do, and what they've done in this case, is they've interjected this racism, and now they want you to become impassioned, to be upset, and then they want you to make quantum leaps in logic and in judgment. They want you to say, Furman is a racist, he planted the glove. You can't get from point A to point B if you just sit down and use your common sense. If you're logical, if you're reasonable, you can't do that. It is true that Furman is racist. And it is also true that he killed these two people. And we proved that he killed the two people, and they proved that Furman is a racist. See, this is my time to talk. Yesterday somebody said that you can't quiet a man's voice in a court of law. This is my time to talk, and I want to talk to you. I heard that the words they spoke yesterday about the Constitution. I read the Constitution. I'm a lawyer. I am a student of the Constitution. I know what it means and what it doesn't mean. I know what it is. Gil Scott-Heron said that the Constitution was just a notebook piece of paper. You remember that? And that's probably true. But what makes it more than that is the fact that there are decent, honest, and courageous people behind it. You can write the law, but if you're not willing to enforce the law, then what is it? What is it worth? You can write the law, you can pass a law, but if people aren't willing to follow the law, then what good is it? I looked back at the Constitution last night. I sent my clerk to go get it for me. And I looked through the Constitution, and you know what I saw? I saw some stuff in the Constitution about Ron and about Nicole. And the Constitution said that Ron and Nicole had the right to liberty. It said that they had the right to life. It said that they had a right to the pursuit of happiness. It said that Nicole didn't have to stay with him if she didn't want to stay with him.